I know it just happened, but for the viewers that are just joining us, kind of paint the picture. What was it like to see Mr. Smollett enter arm in arm with family members and supporters?
Well, first, it was a bit of a scrum outside based on the narrative provided by our colleague Dave Savini, who was outside when the actor arrived surrounded by members of his family. There were some bodyguards and some pushing of members of the media. Somebody pushed to the ground, not exactly sure who, but once they entered the doors of here, it was very quiet. In fact, the entire floor became very quiet. It took them about 5 minutes, the entire group of them. I want to say there was probably about 10 or so, give or take. It took about 5 minutes or so for them to go through security. They all waited, and then they surrounded the former Empire actor Jussie Smollett, and Smollett walked arm in arm with members of his family, his 92-year-old grandmother among them. She will be speaking during the sentencing hearing later this afternoon, and then they quietly walked down the hall and headed up towards the courtroom, presumably, without saying a word. That's not entirely unexpected. I did want to try to ask somebody who was handling the media. I wanted to try to pull her aside and ask why he was late. I know Irv said it will likely not be a factor, but nevertheless, he is going to be 10 plus minutes late to what was supposed to be the start of his hearing, but I wasn't able to do so.
Okay, Dana, we appreciate it. And a programming note for all of us watching on CBS News Chicago, we will bring you that hearing in its entirety. It will first start with basically Team Smollett trying to get a new trial, and then after that, it will likely go on to sentencing.
That's right. We want to go back out now to Dave Savini. He was outside the courtroom. He was the first of our team to get a glimpse of Jussie Smollett and his entire entourage. And Dave, take us back through, with you being so close, could you make out who was there, first of all, and who was involved in the scuffle that you were front and center for?
So as the actor got out of his vehicle, obviously his grandmother got out, and he was surrounded by, I would imagine, some other family members, but he was also surrounded by bodyguards. What do you have? Very large bodyguards. And I can hear you rolling some of the video. The bodyguards started shoving members of the media, mostly photographers. I was one of the only reporters out here. So the photographers are carrying very heavy cameras and backpedaling and trying to move with the crowd. They're shoving them. And can you hear some of that sound right there?
Just tossed the photographer down.
They were knocking people down. They knocked one gentleman down who was a member of the still photographer, a member of a newspaper. I helped pick him up and then continued to ask questions. Are you hearing me, or are you hearing the video that's playing? Okay, I was going to let that breathe for a moment. As you can see, it got very violent, and he was already running late. So he made himself even more late by creating this ruckus here, and he had such a big entourage that they all had to get through security. Irv said it might not be that big of a deal when he shows up before the judge, Judge Lynn, but he wasn't prompt on this day of sentencing. And also, what happened out here? I mean, you can't just throw people to the ground. I said to the man, that's a battery. You can throw people around as you enter the building. So we'll have to see what happens if there's any results from the man that got thrown. I don't know his name. They said he was a veteran member. He's a gray-haired man. And he fell down pretty hard, and it took a while for him to get up. So I'm hoping he's doing well. I don't see him around here at the moment, so maybe he's going to follow up on that himself.
Okay, Dave Savini, our thanks.
Okay, and Dave, thank you for taking us back through this, and now we want to go back over to Irv as we look again at the seal inside the courtroom. So, Irv, this was not an expected piece of the sentencing here, a way that any of us probably expected it to start. Of course, Jussie Smollett has had an entourage with him and doesn't speak to the media. But before we go back inside to get your thoughts on what we're all here for today, what are your thoughts on what happened outside the courthouse from what you're hearing?
You know, what surprises me is this is not the first time we've had a celebrity trial at 26 in California. I recall the R. Kelly trial years ago, and what happened at that time, the sheriffs basically roped off an area where the defendant and his lawyers and other people that were with him went down through ropes and the photographers were blocked off to the side, so there couldn't have been a scrum as like you saw today. And frankly, I'm surprised that we didn't see those roped off passageway that would have avoided the situation that Dave was referring to.
Yeah, I think, and having been in what we call the scrum like that before myself a number of times, the way it is set up, the no boundaries that are set up by the sheriff's office who oversees the court system, protecting its security, etc. I mean, the way it's set up out there, you're just kind of inviting that kind of chaos. So now take us into the courtroom. All we're seeing right now is the seal. Does that typically mean other business is being handled by the judge in this case, and or once Team Smollett enters, will that automatically mean it's go time?
You know, you're going to see that seal until the clerk yells out, people of the state of Illinois versus Jussie Smollett. And at that time, the camera will get off the seal and you'll probably see the judge or you may see the parties. But when nothing is happening, the mic is off in the courtroom and you get that wonderful picture of the Cook County seal up there.
So, Irv, let's go back through the charges. As I know, we're going to hear more of those as the judge begins, the sentencing. But we were talking about the 5 of the 6 counts, and you were making a good point earlier about all it takes is just one at this point for him to be facing potential probation, but also potential jail time and potential time in the penitentiary. So, walk us through those counts. I know a lot of them, or basically all of them, hinge on Jussie Smollett lying to members of the police department, right?
Three members of the police department, 2 statements to 2 and 1 statement to another, actually 3 statements to another. And it doesn't make any difference. If he was convicted of count 1 and not guilty of the other counts, he'd be in the same position then as he is with the conviction of the counts that the jury did come back with guilties on.
And as you've been saying that, we've been giving our viewers just a little background here with those 5 or 6 counts. And we see count 1, that's what he was guilty on. Count 2 as well, telling the same officer he was the victim of a battery. He was found guilty on counts 3 and 4. Same claims against a different officer in count 5. It was that count 6, Irv, that he was not found guilty on. And what was that about there?
That was a statement to a different detective, and a couple weeks later, and so the jury decided that that particular charge, there was not proof beyond a reasonable doubt, but there was proof beyond a reasonable doubt on the counts that they entered guilty findings on. And I remember after everybody came downstairs and the defense attorney talked to the news media, that was his big point. This has to be an inconsistent verdict. You can't find him guilty of 5 and not on 1. And I guarantee you, were his words, that this case will be reversed on appeal. It's not going to happen that way because the courts don't look at it as inconsistent verdicts that will result in a new trial. They look at what the jury used on each individual count. Hey, there was proof beyond a reasonable doubt on these. There wasn't proof beyond a reasonable doubt on the one. No harm, no foul.
As we wait to take that courtroom shot full live for the actual hearing, which we will listen to in its entirety. Irv, I want to get you, I was struck by what you said about an hour or so ago. Let's role play some scenarios here. You said it will be critical, potentially critical for the judge to hear or not hear from Jussie Smollett. Roll through the scenarios. If he hears from Smollett, who basically says, I'm innocent, this whole thing has been a charade perpetrated against me, to, okay, I did it, I'm guilty, I'm sorry. Those words, which will be critical, could affect, in a very real way, his sentence.
No question about it, Brad. I mean, if he basically gets up there and sticks to the story that he told the jury, he may well just have a toothbrush in his pocket. If he continues to demand that he's innocent and he was framed, and the police officers are lying and he's telling the truth. On the other hand, if he basically says, listen, I did lie to the jury, I'm sorry, I'm willing to take my punishment, I'm willing to pay the restitution to the city of the $130,000, I want closure in this case. And frankly, that's the only way that closure is going to happen, is if he takes that route. Because if he's still demanding his innocence, I have no problem with that, if that's the way he wants to do it. But then all that's going to lead to is an appeal in the appellate court. It's going to go on for months, if not years, and closure is not in the cards for that situation.
And Irv, if we can talk a minute about the special prosecutor, and we know, as Dana gave us some great background on and a lot of this controversy with why the charges were dropped by the Cook County State's attorney, but Dan Webb, we saw him enter first, well ahead of schedule. Talk about his role in this and the significance of having a special prosecutor brought in for this case.
It's so rare that this happens. It's only happened several times in the last 10 years that I know of. And it's happened a couple times with Kim Fox's office. He basically volunteered to be the special prosecutor. It's my understanding he's doing it without any compensation to his law firm, with the exception of as costs, because he believes in the system. He believes that what happened in this case was wrong, the way it was handled by the state's attorney's office. And he's an aggressive prosecutor. He was that way when he was the United States attorney here in the Northern District of Illinois. He's well respected. He's well liked. People consider him fair. And it's really going to be interesting to hear what he has to say to the judge as far as what the appropriate sentence should be in this case in his mind. He may not. He may basically say, Judge, I'm asking you to impose a reasonable sentence. Or he may say, Judge, I think he should get probation plus restitution to the city. I believe he should get some community service. And one thing I'd like to add about the restitution to the city, he's not asking for all the money that he's asking for the overtime that was spent by the police department, not the normal pay that all these detectives and beat officers put in, only the overtime, not the hours and hours that were put in without overtime being paid.
Irv, thank you. We have our Charlie DeMar live in the courtroom right now, live tweeting. You just see the seal there right now. 19 minutes ago, Charlie just spoke with Ola Osundaro. As he arrived in court, he said he trusts James Lynn, the judge, to make the right decision, and that he will accept whatever the sentence is. Of course, he's one of the two brothers who were critical in turning this in from an investigation into a potential hate crime into what it has now become the crime that never took place. And then 9 minutes ago, so at 15 minutes after it was supposed to begin, Charlie DeMar tweeted, now Jussie Smollett has arrived for his sentencing hearing. So 15 minutes late there. Let's bring in one of our lawyers. Got a lot of lawyers here. We got Irv, we got Erica, and we've got Kimberly Agowan, our friend from WVON. Kimberly, I'm wondering your thoughts, what your listeners are telling you. Is there some type of demand for a pound of flesh out there? Do people have an investment in it? Do people care what the sentence is? Does he need to do jail time? Your thoughts?
Yeah, Brad, actually not at all. I don't think that our audience is demanding a pound of flesh. I think that they see this as something that's very low priority. Many people were not even thinking about the sentencing phase after he was convicted. I don't even know if anyone was paying much attention to the fact that the sentencing phase was, of course, something that had to take place. It is now taking place. So no, there's no call for the pound of flesh. I know that he almost preemptively did community service at Rainbow Push before he was finally charged again. See, everything is so confusing and convoluted the way in which it was handled. But we do know that he forfeited his bond and that he did community service already. And I just don't think that there is that will out there for individuals to really want to see them put the screws to him and lock him up forever. I do understand the need for trying to make sure that people do not do this again, which is a lie about false charges and tie up the court system, tie up the police
Okay,
officers.
Kimberly, I think I've done this to you every time I've tossed you for a question. I've had to interrupt you. I apologize, my friend, but here we go. Jussie Smollett, front and center. The hearing begins. Erica.
SAMUELMENHALL from the Office of the Special Prosecutor. Counsels?
Thank you. Judge, good morning. Name Chain, NENYE, Boswell, Chief of the Stars.
Good afternoon. Jay Allen, first name SHAY.
Heather Vidal, WITELL, on behalf of Mr. Smollett. Tamara Walker, TAMARA, on behalf of Mr. Smollett.
Good afternoon, Mark Lewis, LEWIS.
Good afternoon, Tina Delandia, GLANDIAN, on behalf of Mr. Smollett.
Thank you, counsels. Everyone may be seated. All right, let the record show that jury trial was held in this manner. Counsels, just trying to see if you will please. Trial commenced on November 29th, 2021. Concluded on December 9th, 2021. Mr. Smollett was found guilty by a jury of 5 and 6 counts of felony disorderly conduct and class 4 offense. I expanded the filing period for filing the post-trial motions beyond the 30-day limit due to the holidays and other restraints involved in this case. I have received an 83-page post-trial motion followed by the defense and a 13-page response to the post-trial motion followed by the Office of Special Prosecutor. I will allow the defense to present arguments in supporting the written motion. Ms. Blandy, if you wish to address the court.
Good afternoon. As the court knows, we filed a comprehensive motion for judgment notwithstanding the verdict and or for a new trial outlining 13 different errors that occurred during Mr. Smollett's trial. However, the legal errors impacting Mr. Smollett predate this criminal trial and began long before this case was even assigned to your honor. I know the court has read our papers and there's been voluminous briefing, and we did incorporate by reference all of our prior briefing and arguments in this case. So I'm not going to belabor every single point. However, I do want to talk about 2 categories of critical errors that have permeated this trial. And that began again at the very outset and impacted this initial complete prosecution against Mr. Smollett. And in doing so, I'm going to highlight some of the most flagrant violations. The first category of legal error relates to this entire second prosecution of Mr. Smollett. The court knows the history, everybody knows the history, but I'm going to outline a couple of key facts that occur. A 16-count indictment was originally filed against Mr. Smollett on March 7, 2019. As a part of a negotiated resolution, on March 26, 2019, the state's attorney's office moved to nollie pros all 16 counts. The Honorable Stephen Watkins granted the motion and dismissed the case against Mr. Smollett. As a part of this negotiated agreement, Mr. Smollett was required to satisfy the Cook County State's Attorney's Office as to his long-standing community service, and he forfeited the $10,000 bail bond, which he was not required to do. Weeks after the case was dismissed on April 5th, 2019, a pro se litigant who lacked any standing to do so filed a petition to appoint a special prosecutor, which was ultimately granted by Judge Tuman on June 21st, 2019. Now, we've challenged the authority of the special prosecutor in different forms. However, when the case came before your honor, we filed a motion to dismiss here. The reason that was relevant is because your honor needs jurisdiction over both the matter and the defendant in order to proceed against him.
And with all due respect, Your Honor lacks jurisdiction and lacked throughout the entirety of these proceedings. And this is because Judge Tuman exceeded his authority when he appointed a special prosecutor, and that's for various reasons. Illinois courts do not possess inherent authority to appoint a special prosecutor in any given case. Rather, the limited authority to appoint a special prosecutor is derived from statute, and it allows the court to appoint a special prosecutor in only 3 discrete situations. The first is when the state's attorney is unable to fulfill her prosecutorial duties. The second is if the state's attorney has an actual conflict of interest in the matter. And the third is when the state's attorney files a petition for recusal. Now, Judge Tuman found that the first of these two were not applicable in this case. And he granted the appointment of a special prosecutor on the third scenario. However, there was no petition for recusal filed in this case, and that's an undisputed fact. In fact, when Sheila O'Brien filed her petition for appointment of a special prosecutor, State's Attorney Kim Fox came forward and she expressly and unambiguously stated that she did not intend to formally or legally recuse herself. But the court nonetheless concluded that what she intended was basically an unconditional legal recusal. Now, subsection A-15 of the statute authorizing the appointment of a special prosecutor doesn't contain a provision which says the court can infer or interpret from the state's attorney's actions whether the state's attorney intended to recuse herself. Rather, the provision is explicit that the subsection only applies when the state's attorney files an actual petition for recusal, which Kim Fox did not do in this case. Because the filing of a petition for recusal is an express statutory prerequisite to the appointment of a special prosecutor under subsection A-15, Judge Tuman exceeded his authority and violated the doctrine of separation of powers by usurping the role of the legislature and essentially redrafting the statute authorizing the appointment of a special prosecutor. Now, to compound matters, Sheila O'Brien also didn't have any standing to file the petition, and the court was not authorized to grant the appointment based on her petition. Now, the language in the special prosecutor statute is very clear as to who is allowed to petition the court for the appointment of a special prosecutor. The language is unambiguous and provides that only the court, the state's attorney, or a quote-unquote interested party may petition the court for the appointment of a special prosecutor. Now, what's an interested party? Well, according to Black's Law Dictionary, an interested party is, quote, the persons who take part in the performance of any act or who are directly interested in any affair, contract, or conveyance, or who are actively concerned in the prosecution and defense of any legal proceeding. Sheila O'Brien doesn't meet any of the requirements of that definition. Sheila O'Brien is a retired former judge who asserted her standing as a concerned citizen, somebody who was not satisfied with the way a duly elected official of Cook County decided to resolve a criminal matter, a low-level, non-violent criminal offense, which they do every single day. But because of the high-profile nature of this case, she was not satisfied and she decided to file a petition. So it's undisputed that she was not an interested party. But putting aside that fact, only the first two subsections, the two that Judge Tuman said are inapplicable, even allow an interested party to file such a petition. Those are the two sections that say the court either on its own motion or on the motion of an interested party. Subsection A-15, which is the one that the Judge Tuman relied on in granting the appointment of a special prosecutor, doesn't say that you could appoint a special prosecutor based on the court's own motion or on the petition of an interested party. That subsection only permits the appointment of a special prosecutor upon the state's attorney's filing of a petition for recusal. It is undisputed that no such petition was filed in this case and that state's attorney Kim Fox never intended to legally recuse herself. Therefore, it was completely exceeding Tuman's authority for him to grant the appointment of a special prosecutor at all. Now, He also misapprehended the law when he ruled that the informal recusal by Kim Fox rendered the entirety of the proceedings from Mr. Smollett's initial arrest all the way through the dismissal of the charges against him null and void. And none of the cases cited by Judge Tuman in his order actually support the court's conclusion that the proceedings against Mr. Smollett are null and void, that the prior ones were null and void. Rather, those cases, and particularly People v. Woodall, and that's 333 Ill Act 3rd 1146, that's a 2002 case, makes clear that even if there had been a defect in the authority to prosecute Mr. Smollett, the only person who could properly challenge the validity of the proceedings would be Mr. Smollett, and he clearly did not do so. Now, separate and apart from the fact that the appointment of a special prosecutor was beyond Judge Tuman's authority, is the fact that Judge Tuman was not authorized to appoint a private attorney, which was Dan Webb and his law firm, Winston & Strawn, as the special prosecutors in this case. Subsection A-20 of the statute provides that prior to appointing a private attorney under this section, the court shall contact public agencies throughout the state to determine a public prosecutor's availability to serve as a special prosecutor at no cost to the county, and the key phrase here is shall appoint a public agency if they are able and willing to accept the appointment. The language in this subsection is mandatory and not permissive. Now, the defense is yet to see any proof that any public agencies whatsoever, including the ones specifically listed in the statute, were properly contacted about the potential appointment. Judge Tuman did represent that he contacted over 100 local public officials or agencies, and that he heard back from only around 30. But by Judge Tuman's own admission, at least 2 and possibly a third public agency was willing to take on the appointment. However, without any explanation, Judge Tuman unilaterally decided that none of these 3 public agencies were quote-unquote able to do so, despite their representations to the contrary. The statute is very clear that the court shall appoint a public agency if they are able and willing to accept the appointment. It's only if after all public agencies have been exhausted and all are unable and unwilling to accept the appointment that the court can then appoint a private attorney, such as Dan Webb and his firm. There is no exception in the statute for private attorneys who might be willing to do the case pro bono or who are willing to do the case simply for costs, not charging for attorney's time, but for their costs, which for a firm like Winston & Strawn is probably still an astronomical amount. And I don't know what the total of the cost is. I know they were supposed to be filing reports with Judge Tuman, I believe every 3 months, to show the taxpayers what their prosecution of Mr. Smollett is costing in tax. And I would be curious to see that figure. I'm not sure what that is, but I would guess it's a substantial amount. But regardless, that is not contained within the statute. And here, because multiple agencies apparently indicated their willingness and ability to accept the appointment, Judge Tuman exceeded his authority and again violated the separation of powers doctrine by usurping the role of the legislator and appointing a private attorney as the special prosecutors in this case. The next issue I'd like to address is that the instant prosecution against Mr. Smollett violated a contractual right to immunity that he was promised by the Cook County State's Attorney's Office. In the original criminal proceedings, there was an immunity type non-prosecution agreement that was entered into between Mr. Smollett and the State's Attorney's Office as an agent of the people of the state of Illinois. Not only was this agreement agreed on between the parties, but it was actually executed and enforced by the court. And it's something that's already been executed. This isn't something where they could renege because it's yet to be performed by either side, but this was actually executed by Mr. Smollett. And the state's promise to Mr. Smollett was that after he satisfied them as to his community service, after he forfeited his $10,000 in bail bond, that the state would not further prosecute him in connection with the January 29, 2019 attack on him. And here we are again in another case instituted, it might be by different attorneys, but it's on behalf of the state of Illinois. And there's a statute that controls, and that's section 5/114-1 of the Code of Criminal Procedure, And it allows the court to dismiss an indictment, and a court is required to dismiss an indictment where the defendant has received immunity from prosecution for the offense charged. And indeed, Illinois courts have consistently dismissed indictments that violate this section. And the courts here analyze informal immunity agreements under the same basic principles of contract law. So Mr. Smollett here performed his side, and he was entitled to the benefit of the bargain he made with the state's attorney's office on behalf of the state of Illinois, and that was violated. And in fact, the state's attorney's office initially they didn't perform their end of the bargain. They stood up in court in front of Judge Watkins, asked for the dismissal, and did what they had promised to do. And so at that point, the agreement was fully performed by both sides. The court enforced it, and there was absolutely no basis, and it was a violation of Mr. Smollett's rights to then re-prosecute him by the same principle, which is the state of Illinois. And there's important policy considerations for this, and the Starks Court, which is People v. Starks 106 Ill 2nd 441 1985, that's an Illinois Supreme Court case, and the Supreme Court in that case explained the significant policy considerations for this rule, and I quote, "The prosecution must honor the terms of agreements it makes with defendants. To dispute the validity of this precept would surely result in the total nullification of the bargaining system between the prosecution and the defense. Therefore, this court believes that if the prosecution did make an agreement with the defendant, it must abide by its agreement in this case." And there's one narrow line of exceptions that applies, and that's in an event of a plea agreement. Obviously, there was no such plea agreement in this case, and Mr. Smollett's present case fits squarely within Starks. And his due process rights have been violated as a result of the instant indictment because he was promised not to be hauled back into court, and that's exactly what happened here. And aside from having to face a second prosecution, he faced all of the things that are attendant with that, from the expense and emotional turmoil and everything else that the second prosecution has entailed. In short, Mr. Smollett relied on the representations by the Cook County State's Attorney's Office, and at the end of the day, a deal is a deal. The state of Illinois is not exempt from that ancient principle, and so we would ask that the case should have been dismissed on that basis. Now, the next issue I'd like to address is the double jeopardy, and we had briefed this before. The court's very familiar with our position on this, but just in brief to highlight a few of our points. The double jeopardy clause does not just prohibit double prosecutions, it also prohibits double punishment. And to punish somebody twice for the same thing is a violation of the Fifth Amendment. And here, Mr. Smollett was clearly punished in the prior criminal proceedings by the imposition of a criminal penalty. Now, certain people may disagree with the severity of that punishment. They may not think that was a just result, but it doesn't take away from the fact that he was criminally punished. And even the Office of the Special Prosecutor, at the outset of the case, when they filed the new indictment, they issued on February 20th, 2020, something called an information release. And in that information release, Dan Webb himself acknowledged that Mr. Smollett had been punished during the prior criminal proceeding. And I quote him when I say that Mr. Webb stated that the only punishment for Mr. Smollett was to perform 15 hours of community service and requiring Mr. Smollett to forfeit his $10,000 bond as restitution to the city of Chicago. Those are Mr. Webb's words, not mine. And he said the only punishment. So he acknowledged that Mr. Smollett had been punished, but again, he wasn't satisfied with that punishment. And that's exactly what the double jeopardy clause is meant to prevent, second guessing of one prosecutor's discretion by another prosecutor. And that's exactly what happened in this case. There was absolutely no rational, non-punitive reason for Mr. Smollett's $10,000 bond forfeiture other than to serve as punishment. Upon the dismissal of the case, his bond normally would have been returned to him, less any bail costs, which would not exceed $100. However, despite Mr. Smollett's full compliance with all bail conditions, the forfeiture of his bond was required as a condition of the dismissal of charges against him. Therefore, this was obviously intended to punish him and serve deterrent purposes. And finally, the fact that he was not convicted of any crimes in the initial prosecution doesn't affect the analysis. In a case decided over 140 years ago, the United States Supreme Court explained, and I quote, "The compromise pleaded must operate for the protection of the distiller, in case against subsequent proceedings as fully as a former conviction or acquittal. He has been punished in the amount paid upon the settlement for the offense with which he was charged, and that should end the present action according to the principle on which a former acquittal or conviction may be invoked to protect against a second punishment for the same offense. To hold otherwise would be to sacrifice a great principle to the mere form of procedure and to render settlements with the government delusive and useless. And for those reasons, the indictment against Mr. Smollett should have been dismissed for violation of the double jeopardy clause." And so, again, here we are at following a trial, and we should have never been here to begin with. There were various critical errors that permeated these proceedings, and the charges against Mr. Smollett and the second indictment should have been dismissed at the outset. Respectfully, Your Honor does not have jurisdiction over this matter, and we believe it was a legal error to proceed. Now, the second category of errors I'm going to discuss are trial-related errors. And these errors began from the outset of the trial, beginning with jury selection, and they went all the way through closing arguments and even jury deliberations. And again, I'm not going to go through all 13 of the errors that we outlined in our papers, but I will highlight some of the critical ones that violated Mr. Smollett's constitutional rights. I think everyone can agree that this was one of the most high-profile cases in recent history. There was an immense amount of prejudicial pretrial publicity and an overwhelming presumption of Mr. Smollett's guilt long before a single piece of evidence was ever presented in a court of law. And this was in part due to a national press campaign by the former police superintendent, Eddie Johnson. And he went on national television on various networks, and he made blatantly false allegations of what the evidence in this case was. And there were three in particular, and these issues were never raised at trial because that's just not what the evidence was. Eddie Johnson went on TV and he said, Mr. Smollett did all of this because he was dissatisfied with his salary on Empire. That was completely a false assertion. That there was zero evidence of that whatsoever. But he went out there and said that and put that in the potential jury pool. He also said that Mr. Smollett had sent himself the letter. Mr. Smollett fully cooperated. He gave his DNA, he gave his fingerprints to the FBI, not to CPD, but he did that to the FBI, and there was no connection between him and the letter. That didn't prevent Eddie Johnson from going out there well before this case ever got to trial and tainting the jury pool with that false assertion. He also said that Mr. Smollett paid the brothers $3,500 for the attack. And it was the brothers' own attorneys who went on TV right after that and said, no, this was actually as corroborated with a lot of text messages between Jussie and Abimbola Asundario. He had hired Abimbola as his trainer, and that's what the $3,500 check was in fact for. Now, based on this overwhelming presumption of guilt in this case, it was critical that jury selection be fair so that Mr. Smollett would receive a fair trial if that was even possible. But there were fundamental errors in that process. First, the court violated Mr. Smollett's Sixth Amendment rights by preventing the defense from actively participating in the voir dire process. The defense sought to directly question the veneer, but the court denied that request. And although the court asked the parties and took questions from both sides as to certain questions that should be asked of the potential jurors, Your Honor didn't ask all of the questions that the defense requested. By refusing to allow the defense to meaningfully participate in the voir dire process, the court prejudiced the defendant's ability to discover those members of the potential panel with biases and or potential prejudices against Mr. Smollett violating Sixth Amendment rights. Although the court repeatedly stated that you didn't want to treat this case any different than other cases, this was an abuse of discretion in this case because of the prejudicial pretrial publicity, which could not be ignored.
And you guys are required to ask every question submitted by your team
We think
to the denier, every single one.
we should have been allowed to participate in this process because of the unique circumstances of this case where there was such an overwhelming presumption of guilt. We think it's a very different process when the court asks questions and when we as attorneys get to ask the right follow-up, in real time without having to wait for it. There are certain questions the court asked, and this was my next point with Rosemary Mazzola, where the court cut off the answers.
I asked most of the questions the defense requested of me. There were some I did not. For example, you wanted me to ask the denier, what kind of animal would you like to be? If you had to be an animal. Or Superman or Batman, what do you prefer? Did you really think I was supposed to ask a denier when I'm choosing a jury in a criminal case and those kind of questions?
We identified certain questions in our motion that we think that there were 4 questions that we thought were critical, not the ones Your Honor just mentioned, but there were
It was part of the pool of questions I received from you.
Right, but there were important questions that were not asked, and the more significant factor is we should have been allowed to question the veneer in this case. Again, I'm not saying in every case. I respect that Your Honor doesn't do that in a lot of other cases. However, this case is obviously unique. Mr. Smollett, unfortunately for him, has not been treated like anyone else charged with Class 4 felonies. He's been disadvantaged at every turn, and his jury selection.
The jury in this case, the same way I pick a jury in a murder case. I do the questions. I ask the lawyers for input. Tell me what questions you want me to ask. I vet them, and I'm happy to ask the questions that are relevant and helpful.
I understand.
Just the only point I'm trying to make is that I absolutely treated him the same as everybody else, and I didn't distinguish him from a Class 4 offender, a potential offender, from a person accused of murder.
I understand, and I think, Your Honor, that's the problem here. A regular murder defendant doesn't walk into court with a presumption of guilt. Mr. Smollett did. There is a presumption of innocence. That was non-existent in this case, and that was due in large part to, as I said, the former police superintendent held a press conference. He went out and did a media campaign. The mayor spoke out on this case. Even Judge Tuman, in his order, before a single piece of evidence had been set forth before Judge Tuman, he convicted Mr. Smollett in his order. He talked about what a charade this was, and he made findings, and Judge Tuman should have been recused. We actually filed a motion for him to recuse himself because based on the face of the order, it was clear that he harbored bias against Mr. Smollett and was convinced of his guilt when he was not ruling on a motion that involved, there was no factual dispute before him. There was no evidence presented to him. And he nonetheless took it upon himself to make improper factual findings, which evidenced his bias. He should have recused himself. However, he didn't even let us intervene in those proceedings to consider our motion for recusal and to consider our motion for reconsideration of the order appointing the special prosecutor. And all of that was there. But to Your Honor's point, the reason I think Your Honor should have treated this case differently is for all the reasons I stated, which is he does not sit and he did not come before Your Honor the same as other defendants with a presumption of innocence, which is what he is afforded and entitled to under the Constitution. Instead, he walked in. I've never seen presumption of guilt the way Mr. Smollett faced, and it deprived him of a fair trial, and the court should have taken precautionary measures during jury selection. There should have been more leeway in this particular case. We made that request, and with all due respect, we believe it was error for the court to deny our active participation in the voir dire process and to ask the questions that we thought were important to be asked. Now, turning to a specific juror, which was Rosemary Mazzola, we specifically asked the court in chambers to further inquire of Ms. Mazzola, since she had told open court, said in open court, that pretty much her entire immediate family are either current or former law enforcement. And there had been no follow-up to ascertain the fact as to whether Ms. Mazzola may have a family member who was actually involved in the investigation of Mr. Smollett or any of the facts surrounding his case. And we brought that to the court's attention. We thought that was a critical question that should be asked, because if we knew one of her relatives, for instance, was involved and helped investigate this case or was partners with someone who was investigating this case, that would have been critical, and obviously she should have been removed for cause. The court denied our request, and we don't think there was any good basis not to bring Ms. Mazzola in and ask her these important questions to make sure that she is unbiased and that she did have no personal conflict. And in fact, several times when Ms. Mazzola was answering the court's question, Your Honor interrupted her, and we don't actually know what she was intending to tell the court and the parties. And for all those reasons, we think that the jury selection process, and the other reasons obviously outlined in our motions, was flawed, and that a new trial must be granted. We also outlined in our papers the improper denial of several Batson motions in response to the Office of the Special Prosecutor's peremptory challenges, which we believe were improperly used to remove jurors based on their race and sexual orientation. Now, I'm not going to detail each of the peremptory challenges that we've outlined in our papers, but in short, anybody looking at this jury can tell that it was not a jury of Mr. Smollett's peers in Chicago. And we think that these significant issues during jury selection deprive Mr. Smollett of his constitutional right to a fair trial, and the remedy is to grant him a new trial. I'm next going to address the issue of prosecutorial misconduct. And this relates to an independent eyewitness, Anthony Moore, who was working as a loss prevention officer for the Sheraton on the night Mr. Smollett was attacked. Now, Mr. Moore does not know Mr. Smollett personally. He was a completely independent witness that police on their own interviewed multiple times. And Mr. Moore spoke to the detectives on at least 3 occasions, including on February 2nd, 2019, and on February 27, 2019 at Area Station. On each of these occasions, Mr. Moore unequivocally told police that around 2 a.m. as he was doing his rounds at the Sheraton, he saw 2 men running towards him from the area where the attack occurred. He said he flashed his flashlight on the first man's face, and he saw a white male wearing a ski mask. Mr. Moore could not see the second man's face. And Mr. Moore was entirely consistent with his repeated descriptions, and he never expressed any doubt as to what he saw. In fact, when asked to view a photo lineup at the station with only Black men included, Mr. Moore told officers that the man couldn't be in the lineup because the man he saw was white. This description of a white male wearing a ski mask was exactly what Mr. Smollett had seen and described to officers. Mr. Moore was a key defense witness, as his testimony provided at the very least reasonable doubt that Mr. Smollett was truthful in his account of what he saw that night. Now, a year later, on January 29th, 2020, prosecutors from the Office of the Special Prosecutor met with Mr. Moore for a lengthy period of time, and they chose not to video record this interview. At trial, Mr. Moore testified that at this meeting, they showed him the CPD's evidence against Mr. Smollett, including surveillance footage and pictures of the Asandario brothers, who they said were Mr. Smollett's attackers. Mr. Moore testified at trial that he felt quote-unquote pressured and threatened to say he saw something he didn't see. And exhausted after hours of telling prosecutors something they did not want to hear, he eventually signed a statement saying he could have been mistaken when he saw a white man, because maybe when he flashed the flashlight on his face, it was the reflection from the light that made him think that the individual was.
Oh my gosh, she's stupid. That is bullshit.
There was absolutely no reason for the Office of the Special Prosecutor to try to taint an independent
black person from a white person.
memory of an event by showing him their version of the evidence and trying to scare him that he would be committing perjury if he testified consistent with his own independent memory of what he saw. This form of intimidation constitutes egregious prosecutorial misconduct and violates Mr. Smollett's fundamental right to present witnesses in his defense. By having Mr. Moore change his statement in writing, not only did the Office of the Special Prosecutor try to disqualify Mr. Moore as an exculpatory defense witness, they actually tried to obtain false incriminating evidence against Mr. Smollett. Although Mr. Moore on the stand tried to explain the reasons, he gave the written statement stating he could have been mistaken about the skin color of the man he saw. The prosecutorial misconduct inevitably discredited Mr. Moore, and this flagrant misconduct constitutes reversible error. Now, the OSP's argument on this issue is really, it's the adage, the best defense is a good offense. They claim in their papers that the defense engaged in gamesmanship and, quote, manufactured prosecutorial misconduct. More outrageously, they claim that Mr. Moore committed perjury when he told the truth. This is belied by the undisputed record, which is that Mr. Moore gave police consistent accounts of what he saw, which is a white man wearing a ski mask, on multiple occasions close in time to the incident. Now, although the Office of the Special Prosecutor presumes that the defense was aware of this prosecutorial misconduct prior to trial, that is simply a false assumption on their part. While Mr. Moore had been identified as a potential defense witness from the start based on his exculpatory statements to police, we only interviewed Mr. Moore for the first time on Friday, December 3rd, just days before he gave his testimony that Monday. And there was no statement to provide to them pursuant to Rule 413D. We had him on our witness list as a potential witness. As Your Honor knows, the defense never knows until well into the trial whether you're even putting on a defense case. We knew he had always consistently said he saw a white man, so that's why he was on our witness list. And the decision was made mid-trial that we didn't want to, in fact, pursue calling him as a defense witness. And we spoke to him briefly. We interviewed him to see why he changed his statement, because it had been very clear that he consistently said one thing, and then a year later, after meeting with the special prosecutors, changed his story a little bit. He was careful in how he did it. He didn't say, I'm wrong, but he said, I may have been mistaken, because again, he wanted to be truthful. And the special prosecutors now say, oh, this was perjury, and the defense suborned perjury. Nothing is farther from the truth, and if the OSP actually believed that, they would have cross-examined him on what happened actually during these meetings. Not only would they have cross-examined him, they could have put up a witness to impeach him who was present during that meeting to say, actually, that's not what happened. They didn't do either of those things. And of course, they could have charged him with perjury, but they won't do that because he was not lying and he was telling the truth. One way or another, this was an egregious violation brought by the Special Prosecutor's Office. They should have been disqualified when we made the request, and a motion for a new trial is required on that basis. And unfortunately, this isn't limited to Mr. Moore. Shortly after, for the second grand jury, when the Special Prosecutor's Office convened the special grand jury to proceed on the second indictment against Mr. Smollett, they had at that time our papers that we had submitted to Judge Truman asking him to reconsider the motion, the order granting a special prosecutor. And what we had done is detail the evidence, the favorable evidence showing that Mr. Smollett was not guilty. And the OSP went to every single favorable defense witness. They didn't call any of them as live witnesses before the grand jury, where they would actually, the grand jurors could potentially ask them questions. What they did is they went to each of them, and every favorable witness somehow changed their account and submitted a statement consistent with the state's theory, even though that was not their original statements 1 year prior. And there were witnesses who suddenly, we couldn't contact anymore, who went missing. This was a real issue in this case. And Mr. Moore was just a prime example of that. Another example was David Allegbe, who similarly had said that he had seen the passengers in his Uber speaking on a cell phone. That wasn't convenient for the prosecution's case because the brothers testified that they didn't have their cell phones with them. And there were two witnesses actually who had said this. There was an independent taxi driver who said one of the brothers was texting during the drive, and separately David Allegbe, who said one of the brothers was on the phone. Now, of course, after we had set that in our papers, OSP talked to David Olegbe and got him to write a statement saying he may have been mistaken about the phone use because it was inconsistent with their theory of the case. And Your Honor saw David Olegbe got on the stand and he explained not only did he hear one of them speaking on the phone for 1 or 2 minutes before the second brother got in the car at their house, which they tried to say he could have been rehearsing his acting lines for that evening, as if the profanities that was yelled at Jussie in the street would have been something that would have to be rehearsed out loud in an Uber. But separate from that, Mr. Olegbe said that halfway through the drive, they changed the destination in the app, which could only be done with the use of a cell phone. And that was not contained in the statement. That was never any of the OSP's disclosures to us. That was something we learned for the first time actually at this trial when Mr. Olegbe testified. In short, we think there were significant issues with the way the OSP treated this case with the defense witnesses, and they tried to have defense witnesses either take back their statements and give incriminating statements towards Mr. Smollett, which were not their original independent stories, or I suppose some of these witnesses, for inexplicable reasons, were just not available, for the defense to reach. So we think certainly a new trial is warranted based on all of these errors, but particularly on Mr. Moore and his statement at trial that he was threatened and pressured by the OSP to change his truthful testimony, which was exculpatory for Mr. Smollett. Next, I'd like to address the burden shifting. The OSP improperly shifted their burden to the defense on 3 different occasions during the trial. As the court well knows, it's entirely the prosecution's burden of proof and is reversible error to try to shift this burden to the defense at any point during the trial. And this happened first during the questioning of Detective Peace, then during the questioning of Abimbola Asundario, and again in the state's rebuttal argument, which was the final word the jury heard from any lawyer prior to retiring to deliberations. The seminal case on a prosecutor's improper comments on a defendant's post-arrest silence is Doyle v. Ohio, and that's 426 U.S. 610, 1976 case, which holds that it is a deprivation of due process to allow an arrested person's silence after that person has been Mirandized and advised of his Fifth Amendment right to remain silent, to then use that silence against them at trial to create an inference of guilt. And that's exactly what the OSP did here on 3 separate occasions. Now, in its opposition papers, the OSP tries to argue that their questions to Detective Peace and to Abimbola Asundario relate to a text message sent on February 14, 2019, and do not involve Mr. Smollett's post-arrest silence. However, the improper questions were not limited to the text message or even to the time period prior to Mr. Smollett's arrest. For example, in questioning Detective Peace, Mr. Mendenhall broadly asked, quote, did he, meaning Mr. Smollett, ever make a statement that they, referring to the Asundario brothers, did nothing wrong and never would? Answer, no. Question, to this day, has he ever come clean about this hate crime that you are aware of? Answer, no. This questioning indisputably violates Doyle, as it necessarily includes Mr. Smollett's post-arrest silence. Furthermore, Illinois law actually goes a step further by holding that it's impermissible to impeach a defendant with his or her post-arrest silence, regardless of whether the silence occurred before or after the defendant was given Miranda warnings. In its opposition papers, the OSP argues that the defense did not object to this line of questioning. However, the OSP's improper burden shifting constitutes plain error affecting Mr. Smollett's substantial rights, for which a lack of an objection is not fatal. Similarly, during the direct examination of Abimbola Asundario, Dan Webb asked him whether Mr. Smollett ever made a statement to the public where he admitted that the hate crime was a hoax. The defense did object to this question, and the court sustained the objection. Similar to Mr. Mendenhall's questions, which were not limited to the text message or even to the time period prior to Mr. Smollett's arrest, Mr. Webb's question is equally problematic. Now, the OSP argues in its opposition papers that the word statements to the public somehow makes Doyle inapplicable. This argument is frankly ridiculous, as any public statements by Mr. Smollett would have been used against him if he testified at trial, the same as if he had made those statements to police. Here, this entire case hinged on the credibility of Mr. Smollett and of the Osendario brothers. By improperly commenting on Mr. Smollett's failure to tell the police or the public that the Osendario brothers did nothing wrong, or to quote-unquote come clean, the OSP violated Mr. Smollett's due process rights and his Fifth Amendment right to remain silent by improperly trying to shift the burden of proof to him. The OSP engaged in further burden shifting during its rebuttal argument, which is particularly prejudicial because it was the last time the jurors heard from any lawyer in this case. During rebuttal, Mr. Mendenhall stated, quote, "Mr. Uche gave you no evidence of any video that was missing." The court overruled the defense objection, which was error. In its opposition papers, the OSP tries to minimize this error by arguing that this was simply a single comment and that it was provoked because defense counsel had argued to the jury that there was a lot of missing data. But that's the prerogative of the defense to argue. Again, it's the state's burden. They put on a lot of surveillance video and they suggested to the jury that they had a complete account from the beginning of the night to the end of the night, and the jury had to be told that these were pieced together, but there was a lot of missing footage. It was proper for the defense to do that. However, it was not proper for the prosecution to put that burden on the defense and ask for the defense to produce the missing surveillance footage, which is simply, again, not our burden to do. And as the court well knows, a single comment is sufficient to constitute reversible error warranting a new trial. And we cited in our papers the case of People v. Giangrande, and that's 101 Ill Act 3rd, 397. It's a 1981 case, and that's instructive. That also involved a single comment by the prosecutor in the closing remarks. And the remark was, "Where's the evidence?" And as the court explained in that case, the comment may well have improperly suggested to the jury that defendant had a burden to introduce evidence. Objection to it was overruled by the trial judge. This was error. And again, it was error in this case for them to make that comment and for Your Honor to overrule that objection. But we'd ask that a new trial be granted on that basis. And I'm going to turn lastly to the accomplice instruction.
Finally. Oh my goodness.
The court in this case committed reversible error when it refused to provide Illinois pattern jury instruction number 3.17 entitled Testimony of an Accomplice with regard to the Osendario brothers' testimony as requested by the defense. Pattern instruction 3.17 provides, quote, "When a witness says he was involved in the commission of a crime with the defendant, the testimony of that witness is subject to suspicion and should be considered by you with caution. It should be carefully examined in light of the other evidence in this case." Now, despite the title, the instruction is not warranted only where a witness is officially charged as an accomplice. Rather, Illinois courts have held that the defendant is entitled to have instruction 3.17 given to the jury if the witness, rather than the defendant, could have been the person responsible for the crime, or if the witness admits being present at the scene of the crime and could have been indicted either as a principal or under a theory of accountability, but denies involvement. Here, both of those circumstances are present, which require giving the accomplice witness jury instruction. The Osendario brothers were initially arrested because the CPD had not only probable cause, but substantial evidence that they were the perpetrators who attacked Mr. Smollett on January 29, 2019. And since then, in statements to the CPD and sworn statements to the grand jury and at trial, the Osendario brothers admitted to doing everything Mr. Smollett told CPD they did. Confront him on the street, yell racial and homophobic slurs at him, punch him, kick him, pour bleach on him, and put a rope around his neck. If it was not for their own self-serving statements and testimony that they did all of the above acts at Mr. Smollett's behest, they would have been charged with a hate crime. or at least a battery against Mr. Smollett. Because the Osundaria brothers could have been the persons responsible for the attack on Mr. Smollett, pattern instruction 3.17 should have been given to the jury. Furthermore, assuming for the sake of argument that the Osundaria brothers were in fact acting at the direction of Mr. Smollett as they alleged at trial, the only reason they were not charged as either co-conspirators or accomplices for their admitted participation in the attack on Mr. Smollett is because of their self-serving statements that they didn't know that Mr. Smollett would report the attack to the police. They asked the jury to believe that the elaborate staged attack was solely for the media's benefit, taking the absurd position that somehow a heinous crime against a high-profile celebrity, which was supposed to be caught on camera, would not result in a police investigation. Because the Osundaria brothers admitted being present at the scene of the attack and could have been charged either as principals or under a theory of accountability, pattern instruction 3.17 should have been given to the jury. Now, the
Charged with what?
Well, Your Honor, they could have been charged with filing a false conspiracy to file a false police report. They could have had
Evidence that they were part of filing a false police report?
Your Honor, there's so much law out there that you could file. There's certainly probable cause to charge them with being an accomplice to Mr. Smollett. Had they not participated, there would be you can't file a so-called false police report if there had been no attack. So clearly they were accomplices, clearly they were co-conspirators. Now, they weren't charged because they took the convenient position. We knew everything until the final step, which, was convenient. And obviously, in any other case, if there were other witnesses, I guarantee the brothers would have been charged. The only reason they weren't charged in this case was because the police needed them to prosecute Mr. Smollett. Without them, there was no case against Mr. Smollett, because as the court saw, there is not a single piece of independent evidence that shows that Mr. Smollett perpetrated a hoax, planned a hoax, or anything else. The only connection, and keep in mind, they subpoenaed or they got a search warrant for 1 entire year of Mr. Smollett's cell phone data, location, text, voicemails, all sorts of communications. They couldn't find one thing that supported the fact that Mr. Smollett planned this. All they had was the brothers saying, after they got caught, after they were in custody for 47 hours, after they had been consulting with an attorney who was speaking to both of them, after that attorney showed them his Good Morning America video while they were in custody and they heard every single thing Mr. Smollett was saying, they conveniently turned around and said, oh yeah, you're right, we did do this, but it's because Mr. Smollett asked us to. And it was their own attorney who said she didn't say that, she gave a radio interview, she didn't say they came clean. She said, I pieced together what happened. I looked at the timeline, I looked at the CPD's evidence, and I put together a timeline of what happened in this case. And it's our belief that that story was spoon-fed to the brothers and that that's the story that they gave police, which allowed them to be released from custody, uncharged. They became the star witnesses, and they've tried to capitalize on this whole regrettable incident. So we had cited the court to People v. Carrion, and that's 162 Ill Act 3rd, 990, 1987. And that's one of the cases we cited in which the trial court's refusal to give such an instruction constituted prejudicial error requiring a new trial. Now, in their papers, the OSP doesn't address or attempt to distinguish this case because there really is no distinguishing factor, and that case is instructive. In that case, the court held that the trial court erred by refusing to give a cautionary accomplice witness instruction with regard to Amaya's testimony for the following reasons. And I quote, Amaya disclosed that he was with the defendant before, during, and after the shootings, notwithstanding his profession of innocence based on his alleged fear of the defendant. We believe probable cause existed to indict Amaya for the offenses, particularly when one considers that when he was initially taken into custody for questioning, he possessed money linking him to the crime. And in that case, the appellate court held that it couldn't find that the failure to give the requested instruction constituted harmless error, especially in light of the fact that Amaya's testimony was the only direct evidence implicating Carrion. And it's the same reason why giving this instruction was critical in this case. where the evidence against Mr. Smollett was far from overwhelming. I know the police department put on a long narrative, a lot of surveillance footage, but all that evidence was consistent with Mr. Smollett's testimony of his actions. He never denied seeing the brothers on the occasions where they went to great lengths to show, on the 25th, he drove to the brothers' apartment. He admitted that. On the 27th, he, met with the brothers. These are not things that were disputed. So that's not overwhelming evidence of his guilt. There were different interpretations of what that evidence actually meant. And the only direct evidence implicating Mr. Smollett was what the Osundario brothers said. And it was reversible error not to instruct the jury that they had a motive to lie about that testimony. It was that story that allowed them to avoid charges in a case where a convicted felon engaged in an attack on Mr. Smollett. He and his brother, if you believe the testimony, agreed to do this despite Ola's prior criminal felony conviction for a very similar attack on another individual, another group attack. But for all of that, it was really their own testimony that's the only direct evidence implicating Mr. Smollett. So under the circumstances of this case, the court should have instructed them that their testimony should have been cautiously scrutinized by the jury. And the court's refusal to provide this instruction under the circumstances of this case was not harmless and constitutes reversible error. In conclusion, I'd just like to say that although we believe each of the 13 errors outlined in our papers independently constitute reversible error and that each warrants the granting of a new trial, even if the court is not persuaded that any one of these errors warrants a new trial, we believe that the totality of trial errors undoubtedly affected the verdict, and the cumulative error certainly warrants a new trial. And there's ample authority supporting the grant of a new trial in such cases. And I'll just cite the court to People v. Lettrich, and that's 413 Ill 172. It's a 1952 case where the Illinois Supreme Court reversed the defendant's murder conviction and death sentence. In that case, there were a number of evidentiary errors alleged, including that the court erred in limiting and restricting the defendant's cross-examination of a critical witness, as well as certain inflammatory and prejudicial remarks to the jury in the arguments by the state's attorneys. In reversing the conviction and sentence, the Illinois Supreme Court stated that the totality of these errors compel us to the conclusion that this defendant has not had the fair and impartial trial, which is the inherent right of every person accused of a crime. And that's the same exact situation we have here. There have been a series of legal errors. If the court is not convinced that any one of them warrants a new trial, we'd ask that the court consider the totality and grant Mr. Smollett a new trial.
Thank you, counsel. Governor, wish to make a response to the post-trial motion of the defense?
We do, Your Honor.
Mr. Weaver, you may address the court.
May it please the court, counsel. Your Honor, due to the sheer volume of the arguments here, about an hour here, and you've already mentioned 83 pages that they've submitted. My partner and fellow deputy special prosecutor Salmon and all have bifurcated the opposition. I'll give an overview, and based on Ms. Gladian's presentation, I'll highlight 4 alleged errors. I believe Mr. Mitchell will have a couple. To begin, I'll just start with a blanket statement that for everything prior to November 29, 2021, going backwards to 2019, for the alleged errors that they've incorporated by reference in their papers and the preamble to Ms. Gladian's presentation, we universally disagree that there is any error in those prior rulings, and we too, in our opposition and here today, will incorporate not retread them, but the record is clear for the issues that have been presented to Judge Tubman, for which we have been involved, for the issues that have been presented to this court, for which we have been involved, and for the issues that have been presented to the Illinois Supreme Court, for which we've been involved, are all incorporated by reference at each stage, and no matter the court or the judge that have heard it, each one of those prior rulings were proper, required by the law, and none need be nor should be revisited. And since Ms. Lanyon brought it up, it probably is a good reminder that my firm of Winston and Strawn and the partnership did take this case pro bono. And our firm did, and Mr. Webb in particular, did shoulder that burden that was called for by the appointment of a special prosecutor. And we did so the entirety of the attorney time free of charge. Not a dime. Limited expenses in the normal court. Judge Tubman's order did allow, and these are things such as court reporter fees, transcript fees, copying fees, those same fees that would exist for the Cook County State's Attorney's Office are expenses for which have been submitted to the county for reimbursement. They are minor compared to the amount of free service that our firm of Winston and Strawn has given to this county and to the citizens and to the judicial system. Mr. Webb's appointment in particular as a special prosecutor was stemmed from Judge Tubman's 2019 June order in order to restore the public's confidence into the integrity of the criminal justice system, was answered by our firm, was answered by Mr. Webb, and you might just recall the two directives that required. The first directive to determine whether Mr. Smollett should be further prosecuted. That's what we're here for today. But it shouldn't be forgotten, I don't believe it is, but it's worth remembering the second directive. Whether any person or office involved in the initial Mr. Smollett case engaged in any wrongdoing, our office also did that. And you heard Ms. Lanyon talk about certain of those things in our argument, that the OSP did complete a thorough investigation, did have a grand jury seated, did prepare a detailed and comprehensive report as it relates into the Cook County State's Attorney's Office, as it relates to the investigation in the Chicago Police Department, and did so for a total cost of attorney times for $0.00. And it should be noted, since it was raised, and it's important to understand that we believe we have fulfilled the call to restore the public's confidence into the integrity of the criminal justice system. As to the actual substance of Ms. Lanyon's presentation, and as it relates to the 13, what I'll call macro level alleged errors, although they list a myriad of alleged sub-errors as well. The evidence presented at trial, Your Honor, overwhelmingly established Mr. Smollett's guilt beyond a reasonable doubt. And that's reflected in the jurors' unanimous guilty verdict. And nevertheless, Mr. Smollett asked this court for extraordinary relief to overturn the jury's verdict that found him guilty of 5 serious felonies of making false police reports. And in doing so, he raises a variety of alleged procedural, alleged evidentiary errors, both pre-trial and during the trial itself, committed by anyone and everyone involved in this case, except, of course, Mr. Smollett himself or his lawyers. And just a few examples. He's blamed the prosecutors. He's blamed Your Honor specifically. He's blamed the courtroom staff. These are his favors. He's blamed the Cook County sheriffs in this courtroom. He's blamed the entire Cook County judicial system. He's blamed the Illinois Supreme Court. He's blamed COVID-19. He's blamed the media. He's blamed, quote, political figures. He's blamed witnesses at trial. And he's even blamed the jury itself. Page after page after page of finger pointing and scapegoating. But once that bluster and hyperbole, Your Honor, is excised from that motion, and the examination of the real underlying record is undertaken, it clearly reveals that each of the alleged errors is 1, meritless, 2, It is riddled with distortions of the actual record, and 3, frequent misapplication of controlling Illinois law. But most important, none of those alleged supposed errors remotely would rise to the level of 1, requiring overturning the jurors' unanimous verdict, nor 2, the issuance of a new trial. As it relates to the alleged errors where Mr. Smollett seeks a judgment notwithstanding the verdict, here's what you didn't hear. You did not hear what the law actually says and what you'll have to weigh today. So I'm going to give it to you. Illinois law mandates that a judgment of acquittal is only appropriate when, quote, a trial court concludes, after viewing all the evidence in the light most favorable to the state, that no reasonable juror could find that the state had not met its burden of proving the defendant guilty beyond a reasonable doubt. And, quote, a motion for judgment notwithstanding the verdict should be granted in instances only where the state's evidence, when viewed in the light most favorable to the state, is insufficient to support a finding or verdict of guilty. Here, Mr. Smollett has not met and cannot meet the incredibly high standard for overturning the jury's verdict, and when viewed in the light most favorable to the state, that's the OSP in this instance, the evidence presented during the almost 2-week trial overwhelmingly, beyond a reasonable doubt, demonstrated that Mr. Smollett devised, orchestrated, carried out a fake hate crime, and then, in violation of Illinois law, repeatedly reported that fake hate crime to the Chicago Police Department as a real hate crime. And the plethora of evidence, just heard Ms. Glanian say, not a lot of evidence, or certainly not a lot of independent evidence. Here's a summary. The testimony of 5 Chicago police detectives and officers. The jurors heard the testimony of the Osendero brothers. The jurors heard cross-examination by the defense of each of those witnesses. The jurors received into evidence over 40 exhibits, including phone records, text messages, social media evidence, video surveillance, GPS evidence, receipts, and a $3,500 check written by Mr. Smollett to the younger Osendero brother. They heard the testimony of the defendant's 6 witnesses, and they heard Mr. Smollett himself. Hours and hours and hours worth of the defendant's own testimony. All that evidence, when viewed in the light most favorable to the OSP, it simply cannot be said with a straight face that no reasonable juror could find that the OSP did not meet its burden in proving Mr. Smollett guilty beyond a reasonable doubt. That's for the JNOV portion. As it relates to the remaining alleged errors that do not go to the sufficiency of the evidence at trial, that's when they say that those are more appropriate, perhaps, for a motion for a new trial. Illinois law tells us that a post-trial motion for a new trial is a matter for the trial court's discretion. Because none of the alleged trial errors you've heard or seen in their papers have any merit, this court should exercise its discretion and deny Mr. Smollett's alternative relief for a new trial. As it relates to the 4 errors I alluded to, Your Honor, that I just want to give a counter narrative to, since they were raised. 3 were raised. That's on the voir dire issue, the Batson issue, the accomplice instruction, and then I think it's also important to briefly touch upon one written about but not discussed here, which is the concept of the violation of his public trial rights. I'll just go in the order. Alleged error as it relates to the voir dire. The court's voir dire process was plainly consistent with Illinois law and consistent with Rule 431. Notably, defense counsel didn't raise any objection at trial as it relates to the actual conduction. The rules language, as the court deems appropriate in Rule 431, makes clear that a decision as to whether to allow direct questioning is entirely within this court's discretion. Per Rule 431, the court conducted voir dire by directly questioning the prospective jurors, but consistent with Rule 431, the court exercised its discretion and allowed the parties to submit voluminous questions to be asked during the voir dire. Both sides. Both the OSP and the defense submitted rather voluminous supplemental questions for further inquiry of prospective jurors. Pre-trial, we reviewed those very thoroughly. We had colloquies on them, we had hearings on them, we had exchanges on them. Defense counsel ultimately submitted nearly 60 supplemental questions to ask during voir dire. The court took input, and importantly took input from the parties throughout the voir dire process, both at sidebar, in chambers, pre-trial, and during trial. And those additional follow-ups were often asked of the prospective jurors, and when they were not, the court explained why, in your Honor's discretion, they would not be asked. No prejudice exists. Defense counsel was permitted to question the prospective jurors through the extensive supplemental questions, that they submitted pre-trial, and through the supplemental requests that occurred during trial. Alleged error number 2, the Batson challenges. And I'll begin by noting unequivocally, the accusation that the OSP engaged in, quote, a systematic pattern of discriminatory challenges, end quote, is absolutely meritless. Lodging unfounded accusations of jury discrimination that are belied by the actual record is unfortunately completely consistent with Mr. Smollett's attempts to interject and weaponize race and sexual orientation into these proceedings more generally. Just as he did when reporting the fake hate crimes to the Chicago police in 2019, just as he did when he took to the airwaves in 2019 in what is now perhaps the now infamous Good Morning America interview. The court heard defense motions made under Batson versus Kentucky as to the OSP's use of his preemptory strikes. Those occurred in chambers on the record. And when such motions were made, as your Honor knows, under the Batson case, but also under Illinois law and People versus Davis, the defendant must first make a prima facie showing that the prosecutor has exercised preemptory challenges on the basis of race. And the court correctly concluded at the time, analyzed those motions under the standard articulated both in Batson and Davis, and found that the defense had not made a prima facie case of discrimination on the basis of race or sexual orientation. But even though it wasn't required to, the OSP, because of the challenges, even though a prima facie case had not been shown, the OSP did provide neutral explanations both for race and sex as to each of the preemptive challenges at issue. But rather than grapple with that actual record, which they didn't, you didn't hear it today, they didn't grapple with the actual record, and they didn't do it in the papers either. Because if you looked at the record and you saw things and the explanations as it relates to the challenges, undisclosed, disorderly conduct incident, a victim of a hate crime, avid watchers of Empire, getting news from TMZ, watching movies that starred Mr. Smollett, Googling the case, getting news only from social media or from Instagram, struggling to understand or hear questions. If they actually grappled with the actual record, it wouldn't fit the narrative that they wanted out in the media. Unequivocally, meritless motions that were offered, the court's prior rulings, all should stand on that point. As it relates to the alleged error number 3, the accomplice instruction on the IPI, the Illinois pattern instructions. As your Honor knows, the court has discretion to determine which jury instruction should be given. Defense counsel sought, and you heard it here today, to include 3.17, that's the testimony of an accomplice, in the jury instructions. They've done it again here today to try to define the fake attack on Mr. Smollett, which is not a crime, as a crime for which the IPI 3.17, how they would like it to have been analyzed in the application of that instruction. But IPI 3.17 on its face has no application to this case. The Osendaro brothers did not admit, nor was there any evidence that they were involved in the commission of a crime with the defendant. That's the language from 3.17. What is that? It would be filing the false police reports. And Mr. Smollett, not the Osindaro brothers, made the decision to file multiple police reports, false police reports, claiming he was the victim of an alleged hate crime. The Osindaro brothers could not have been the person responsible for the crime. That's what's required to get a 3.17 instruction, because they did not assist nor participate with Mr. Smollett in the filing of the false police reports. Moreover, Your Honor, the Osindaro brothers did not admit to participating or otherwise being present to the reporting of the fake hate crime to the police. Therefore, they could not have been indicted for disorderly conduct or for filing a false police report. The court properly and correctly exercised its discretion in not giving the 3.17 instruction, and that ruling should stand. Lastly, Your Honor, a significant amount of ink was put into the last topic I'm going to discuss, which is the right to a public trial. As everyone in this room knows, this trial took place in the middle of a global pandemic, right on the cusp of the Omicron variant. This court did a great job holding a public trial. All necessary parties, the court, courtroom staff, Cook County sheriffs, the OSP, defense counsel, the jury, media, numerous members of Mr. Smollett's family, numerous of his friends, members of the public at large, were able to attend every single day of the trial proceedings. The logistical efforts for which the defense has taken swipes at this court and this courthouse deserve to be commended, not bashed. The defense objected to having cameras in this courtroom during the actual trial, and they objected to having cameras in this courtroom at every step of the way. And the court respected that objection in declining extended media coverage up until today's hearing. Having the cameras in the courtroom, which they objected to, would have allowed an unlimited number of people to view the trial. Their papers struggle with this. They acknowledge the position. I'll coin it sort of their Goldilocks position. Your Honor, don't make the trial too public. And then once you did that, today it's not public enough. And they've alleged that no members of the press were in the courtroom during any of the jury selection process. Not so. The court knows. So there were at least two members of the media that were present in the courtroom, probably both of whom are here today, that sat in the corners during the process of voir dire. Many more were sitting at the courtroom exits and standing. These doors were open. Those doors were open. The doors to the Honor's courtroom across the hallway were open. Chairs were provided. And while the sheriffs did a great job trying to get people in the seats, there were a lot more people that weren't in seats. And for anyone that actually sat in here, which they did, I did, they did, knows there's a lot of people peeking in and out during the voir dire process. The concept that Your Honor closed the courtroom just belies reality. Your Honor kept the courtroom open. Members of the press were here. They were able to keep account of what was occurring. In fact, were accounting as to what was occurring. It doesn't remotely come close to any violation. The Radford case, which we cite, demonstrates that the court's use of the entire courtroom for the veneer, but not for the remaining portion, doesn't call into the question the confidence of the public integrity or impartiality of the court system. Mr. Smollett knows he had family present. They sat right there. They had strategy huddles. They passed numerous notes to his lawyers. They held prayer sessions. You allowed his entire defense team, his PR team, his friends. You never took a head count on them. You were gracious in understanding that the defendant's right to a fair trial had to be weighed against a global pandemic, and it was commendable. You did not err, and you certainly did not violate Mr. Smollett's Sixth Amendment right, and he certainly doesn't deserve a new trial. Generally, but certainly for that specifically. With that, Your Honor, if you have any questions, I'd like to turn it over to Mr. Minnick.
Your Honor, Ms. Blandon is entitled to her own argument. What she is not entitled to is her own facts. She stood before this court and told you they raised the issue of David Elderly's direct examination. Nowhere in this 83-page motion did they ever make a single complaint about the examination of David Elderly. Ms. Blandon stood before this court and told you that they made a motion to recuse the whole office of special prosecutor, Mr. Webb, myself, Mr. Weaver. Nowhere at trial or in this paper is there such a motion. Your Honor, as we established at trial, facts matter, truth matters, evidence matters. They are not entitled to their own facts. Another fact in this matter, Your Honor, the one disqualification that they did make was to recuse the deputy special prosecutor who examined Mr. Moore. That deputy special prosecutor is an honorable man, is a man I worked with for 20 years. His integrity is impeccable, his reputation is impeccable, and his ethics is impeccable. Your Honor, they say he put Mr. Moore on the stand to commit perjury. Mr. Moore got on the stand and testified that the person he saw was white. Your Honor is well aware the actual two people that ran by him got on the stand and testified. Abel Ola Osendira. Your Honor, if nothing else has been established in this entire trial, I think we can both agree it's been established that they're not white. Yet they came here today and making that same argument. Their argument is in why they're not getting better with age. Your Honor, to try to discredit a man and to call into the courtroom when all he did is serve pro bono faithfully and for free does a disservice to the job that this office of the special prosecutor did. And not only did they not prove anything that merited disqualification, they did it with pure gamesmanship, Your Honor. The rules require that you bring it to the court's attention in advance. They waited until the witness got on the stand and had him point at the deputy special prosecutor. Your Honor, and these are your words exactly, Your Honor, you said this was the first time in your history of the judge where you ever seen a witness get on the stand and point at a prosecutor. I've never seen it. I suspect no one in here has ever seen that. Your Honor, the gamesmanship cannot be rewarded. Their alleged error that the deputy prosecutor should be disqualified should be summarily denied as meritless. Second point of error, Ms. Blandon raised. She said that the Office of the Special Prosecutor commented on Mr. Smollett's post-arrest silence and post-Miranda silence. We did no such thing. On February 14, 2019, in an unsolicited, voluntary, non-custodial interview with the Chicago Police Department, Mr. Osendiro sends Abimbola Osendiro a text saying, "Brother, I love you. I know 1000% you did nothing wrong. and never would. Neither you nor your brother. I love you, I stand with you, and I'm going to make a statement making sure everybody knows you did nothing wrong. It was voluntary, it was non-custodial. How do we know it was non-custodial, Your Honor? Mr. Smollett got up and left after the interview. He wasn't taken in custody and was represented by one of the finest lawyers in Chicago. To say that when we questioned Detective Deese about that text, that we put in play Mr. Smollett's post-arrest silence.
I hear sirens in the background. What is going on in Chicago? Lord have mercy.
Text that he sent when he was free to go and did in fact leave is wholly without merit, Your Honor. To then say that when Mr. Webb questioned Admin Bolos and Durham about the same text that he received from Mr. Smollett on February 14th, way before Mr. Smollett was ever arrested, way before he was even Mirandized, is equally without merit, Your Honor. The text stands for itself. Their problem isn't with the question. Their problem is with the text that their client said. Because it said a lot. I know you did nothing wrong. I know you never would. I know 1,000% you did. I love you and I stand with you. And I'm going to make it right. We had every right to ask if that was ever made right. And lastly, Your Honor, they raised an error that we allegedly shifted the burden during trial. They alleged 3 separate times. Once again, Your Honor, facts matter, truth matter, evidence matter. In their 83-page brief, they raised one issue concerning that, and that was at closing. When Mr. Uche stood right there in his very well, looked at the jury and told them, ladies and gentlemen, there was a ton of videos missing, there was a ton of evidence missing. The case law is clear on that, Your Honor, that when the defense opens the door in closing argument and raises an issue, the prosecution or the state has an absolute right to respond. They open the door, and now they're complaining that we walked in. We walked through it. Your Honor, we simply responded to his claim that there was missing evidence. Detective Deese took that stand and made it abundantly clear. Not a single piece of video was missing. Every video that we had was turned over and that they had. No video was missing, Your Honor. And for them to raise that argument, we were entitled to respond. Your Honor, so my role was to address the trial errors. I wanted to do it in a summary fashion because we've been going a while now. But those 3 areas that Ms. Landy raised are simply not supported by the record. She's entitled to her own argument. She's not entitled to her own facts. We thank you for your time. We respectfully ask that you deny the motion and the state is ready to proceed to sentence.
Anything else you want to add?
Very briefly, Your Honor.
Your Honor, Mr. Mendenhall began talking about the second prong of their appointment by Judge Truman, which was to see if there was any wrongdoing in the dismissal of the charges against Mr. Smollett in the initial indictment. Now, I know there was some public outcry after the sudden dismissal of the charges. However, the OSP did a thorough investigation, and the one thing they did not find was any misconduct on the part of Mr. Smollett, anybody surrounding him or his team, in the dismissal of the charges against him. And that's critical because that impacts the fact that the agreement should have been honored. Now, whatever may or may not have gone on at the state's attorney's office, whatever the inner workings are, has nothing to do with the expectation that Mr. Smollett had when he entered into an agreement. He performed his part. The state's attorney's office at the time performed their part. The court enforced that agreement. And again, we know from the OSP's investigation that there was absolutely no wrongdoing on the part of the defense in bringing about the dismissal of charges against him. That was something that was offered in the discretion of the state's attorney's office, and he was entitled to rely upon it, which he did to his detriment. As far as the voir dire questions, I just want to emphasize that we're not talking about every single question. I know Your Honor asked a few questions which raised a few examples saying that those are not things that needed to be asked. For the record, I just want to identify the 4 questions that we thought were significant to determine if any of the potential jurors had any prejudices or bias that would deprive Mr. Smollett a fair trial, and the 4 questions that we had asked the court to inquire of the potential jurors and that we believed based on this court's order stating that the court would address these topics were: number 1, are you or is anyone close to you a member of the mainstream media? 2, do you have any particular feelings one way or another about actors? And this was critical because Mr. Smollett as an actor testified. 3, would the sexual orientation of Mr. Smollett or any witness have any bearing on your ability to reach a fair decision in this case? And 4, do you believe that you would give more or less weight to the testimony of a law enforcement officer as opposed to the average citizen? And these were important questions, again, in light of—
Are you sure those questions weren't asked, albeit in my words, not your words? Are you sure about that?
Yes, Your Honor. We've reviewed the record. We put this in our motions. Again,
I think you may be mistaken.
our review of the record tells us otherwise. Now, as far as the accomplice instruction, Mr. Weaver said that the Osundario brothers could not have been charged with filing a false report because they weren't present when Mr. Smollett reported the attack to police. That is completely absurd. It's like saying somebody can't be charged as an accomplice to murder or a co-conspirator in a murder if they're not physically standing there when someone shoots the gun. It's a silly argument. The Osundario brothers absolutely could have been charged as an accomplice or a co-conspirator. There was probable cause. Despite their denial, they could have been charged. People in courtrooms all across the country are charged every single day with less evidence for conspiracy-based crimes or as an accomplice. They absolutely could have been charged in this case. The CPD and the state's attorney's office made a decision not to charge them because they wanted their testimony against Mr. Smollett, but that doesn't mean they couldn't have been charged, and it doesn't mean that the instruction should not have been given because they do satisfy the requirements necessary requiring that instruction to be given. And Mr. Mendenhall stated, I'm not entitled to my own facts. I'm certainly not here creating any facts. The record speaks for itself. Anthony Moore took the stand. He stated what he stated. We have the transcripts to show that. And he's the one who got up on the stand and said he was threatened and pressured. And when I made reference to disqualification, I certainly wasn't suggesting that we asked for the entire OSP to be disqualified. I was up here, I'm not trying to name any individuals. Our papers are clear as to our disqualification motion. I believe Your Honor already knows that. And finally, just to address the post-arrest silence issue, Mr. Mendenhall wants to isolate the statements as relating to the text message, and he says that these were all statements, or he was referring to the fact that that text message exchange on February 14th was prior to the fact that Mr. Smollett was arrested. However, that's not the question that was asked, and that's not what the jury heard. The questions said, to this day, has Mr. Smollett ever come clean? Has he ever said that the Osundario brother, it basically says, has he ever corrected the record? And it was specifically, the language was to this day, and has he ever? And so that necessarily includes post-Miranda, as he was sitting in trial as a criminal defendant. And so we think all of those things were error. And as far as the burden shifting, Mr. Mendenhall says there was no missing video. There in fact was. There was no video footage of one of the taxi rides, which made no sense because it had been, the CPD had apparently obtained that video. However, it was nowhere in the discovery. Later, we were told it doesn't exist. But there was missing video, not to mention all of the pieces of surveillance footage that obviously they weren't able to obtain. So again, it was fair game for the defense to comment on those things as the prosecutor's failure to meet their burden and to have the jury wonder about those things. It was not fair game for the prosecutor to do what they did, which is shift the burden and put it on Mr. Smollett to have to prove his innocence and have to come up with this evidence that he simply didn't have. So again, as we ask the court to grant a new trial in light of the totality of errors that have occurred and have deprived Mr. Smollett of a fair trial. Thank you.
Everybody
Oh,
know?
Lord, somebody call the paramedics.
Okay. All right, let me indicate that we've been talking about these very issues for the last couple of years. Most of them are pre-trial, and certainly there's some that took place at trial. I've never had a case that has been pled as exhaustively as this one.
You heard the judge?
Hundreds and hundreds of
He said
pages,
exhaustively.
filings, asking for multiple
This
motions,
is sad.
jeopardy claims,
Coming up 2 hours.
disqualified
Oh,
counsels, all of which are contained in the
damn.
post-trial motion. It's fair to contain the post-trial motion, but I mention now that these have been vetted and records have been made, and I've articulated myself at great length on all these issues in the past. I am comfortable with the colloquies that were had and the decisions I made as a result of those colloquies. Just a few matters right now I want to address, and I think I should because they've been brought up with some passion by Ms. Glandian. There has been some suggestion that somehow this court should not have allowed the second indictment to go forward because it was invalid, because somehow Judge Leroy Martin, Chief of the Criminal Division at that time, when he appointed Michael Tuman, or asked Michael Tuman to be the one to preside over Sheila O'Brien's petition seeking a special prosecutor, that somehow that was flawed. That Judge Tuman, when he held hearings, and he held exhaustive hearings, and his report speaks for itself, that somehow those proceedings were flawed, and a special prosecutor never should have been appointed, and that I somehow should have been in a position to grant some kind of collateral relief and dismiss the second indictment because the appointment of special prosecutor in the first place was invalid. I read all of those transcripts, everything that took place in all of the hearings.
You're crazy.
Judge Tuman issued his report. He took it under advisement.
Oh, you guys make me laugh. Oh, Jesus.
He found that the appointment of the special prosecutor was necessary. Now, that doesn't mean that he's assuming that Mr. Smollett's guilty of something. It didn't mean that he assumed that the Cook County State's Attorney's Office was guilty of some misconduct or had done something terribly untoward or unethical. All it meant was that under the totality of circumstances, a second look was necessary. That public confidence in this entire affair was shaken, and a second look was necessary. He appointed Winston Strong, Dan Webb in particular. I find nothing wrong with Judge Tuman's reasoning, his analysis. I'm not sure I have the right to offer collateral remedy because I'm just a trial court judge on the same level as Judge Martin and Tuman. But be that as it may, I happen to agree with their reasoning that they found that the appointment of the special prosecutor was necessary, and all they did was investigate, and then they found things after that. A report was made about the Cook County State Attorney's Office, and obviously a second indictment came as a result of their investigation about the circumstances of the case involving the conduct involving Mr. Smollett. All right, that's that. As to a public trial, we were in COVID. This was the first jury trial that this court held, and I am an active jury litigator and have been for years and years and years. This is the first trial I was able to have since COVID, and COVID was still happening. We were under all kinds of constraints. I was told that I could only have half capacity in the courtroom, including the jurors, including the deputies, including the lawyers. I had multiple lawyers on each side. I think the defense team is 6 lawyers. The prosecution with their staff is even more. I asked the parties, how many seats do you need in the courtroom? The defense came to me at first and they said, we need 42 seats in the courtroom. That's 42 out of 57, including the jurors. I had media requests. The defense told me specifically, I asked them, do you want cameras in the courtroom? Shall this be televised? The defense said, no, we would not like it televised. The prosecution said, we don't take any position. Whatever Your Honor decides is fine. But I deferred to the defense. I understood that this is a delicate matter. They preferred not to have it on television.
Oh my God, Your Honor, killing me.
Marie,
please.
on television. I did the best I could to have a public trial. We did things that we don't normally do. We kept the doors open. We had seats outside the doors that were open. We had seats set aside for the media because I knew that the media would be making this as public as possible. We did have people coming to the courtroom, and ultimately, and there was no limit on the amount of people that were here as family and supporters of Mr. Smollett. So I am confident that I did all I could to give a public trial that the Constitution requires. We were under severe limitations based on the COVID virus. Last thing I want to talk about is the accomplice instruction. There's been a lot of talk about this, and I did take this seriously at the time when it was brought up. We have to remember why we are here. Mr. Smollett was indicted for filing a false police report, felony disorderly conduct. Everything about what happened between he and the brothers, the plan that the jury found happened, the scheme to meet on the street and pretend to beat him up and call him names and do the things that they did, none of that's a crime. There was, because Mr. Smollett was consenting to it, not only consenting to it, he had orchestrated it, according to the evidence. There's nothing you could find the brothers guilty of. They didn't commit any crime. The only crime that was at play in this entire scenario was the false police report. When the police were called, the brothers were no longer there. They weren't consulted. They were out of the picture. The problem that Mr. Smollett has are what he said to the police and what the jury found that he said to the police, and that it was patently false. That was the problem. And the brothers had nothing to do with that. And because the crime at issue was the filing of the false police report, the felony disorderly conduct counts, I found that the brothers had nothing to do with that portion of it, and the accomplice instruction for those reasons would not lie. And so I just want to put that to rest. And we talked about that at length previously, and I know Ms. Landy is serious about it. That's fine. But I see no problem with that. As to the rest of it, we've talked about this for 2 years, and I have made records both orally and in writing on each of these issues, even some things that were not raised orally today. I'm going to stand by my findings and rulings. I do believe at the end of the day that Mr. Smollett received a fair trial, that he was proven guilty beyond a reasonable doubt by the jury based on the evidence that was presented, that there was nothing unconstitutional about these proceedings. His motion for post-trial relief was respectfully denied. I'm going to go further.
Yay! All right. Thank you, Judge.
And we're going on to the sentencing hearing. Let's take 10 minutes.
Judge says he got a fair trial, so no dismissal of this case. Amen. Now on to the sentencing phase. Thank you for joining me. This is Everyday Shenanigans.
To the motion, the request for a new trial, and we've heard it, boy, we've been going back and forth here, both sides for upwards of almost 2 hours now. They convened court just a little bit after 1:30, and here we are at 3:10, so that gives you an idea of how long it's taken just for this first half of what we're considering in the sentencing hearing for Jussie Smollett. And they are taking a short recess, so that's why we are back on the seal here at the courthouse at the Layton Criminal Court Building, and we will wait to see how long they will continue to be in recess before they move on to the next stage. So, at this point, we are still waiting to hear from many of the witnesses that Jussie Smollett and his team will put forward, including his 92-year-old grandmother.
Oh my God. How long is this going to go? I'm not getting ready to stay on live this long. My goodness.
And, will be speaking as well. He was accompanied by many of them as they walked into the courtroom. And from what I'm understanding from Irv Miller, we'll bring him in shortly, many of these letters that we have been getting in preparation for the sentencing hearing, those will be quoted from, a lot of them coming from Jussie Jackson locally and the NAACP. So I want to bring in Irv Miller now. Irv, you've been listening to a lot of this, I'm sure, and, it's extensive. Even at times, the judge stepping in to question many times Jussie Smollett's attorney on some of the points that she was making here. So what stood out to you?
What stood out to me was what the judge thought was important, because he didn't comment upon everything that either side brought up to him, but he did spend a lot of time talking about what happened before Judge Tooman in appointing the special prosecutor's office to begin with, because he knows that
I'm going to turn this down. I'm just going to watch it from here to see when they reconvene the recess, because this has gone on longer than I anticipated, but I should have known better. It is court, so that's my fault. Not assessing how long it would take for this to go on. I had other information I wanted to bring you guys, so I've got it watching on one of my other little monitors that it's still going on. It's in recess. I will play it when they resume, but it's probably going to be even longer because now they're talking about his 92-year-old grandmother speaking. And see, I don't know how many more witnesses are going to come forward to speak on his behalf before the judge renders a sentencing. This is just absolutely asinine, but it is the law. Everyone has a chance to speak. And then first, the defense attorney spoke on behalf of their client. Then we had the prosecution give their rendition. And then I also believe she was able to rebuttal whatever he said. I mean, the judicial system is just, it can be very winded. And this is just BS. But let me tell everyone in the chat and those coming in, the defense for Jussie Smollett requested a new trial. It has been denied by the judge. And right now they're in a short recess. Thank you all so much for joining me. This is Everyday Shenanigans. If you want to donate to the channel, $Big Angie 129 Cash App. Also, per chat to welcome during the live. I want to go on and start talking about something else while they're in recess, because this is taking up a lot of my time, and I can't go 4 hours on this nonsense. This is BS. I want to talk about oh, my phone is acting up. Oh God. I've got Megan Boswell that I want to talk about, and something else. My devices are acting horrible. One moment. Hold on, you guys. That is not what I put up there. Let me see. Hold on. I can't even find my own posts. Things I want to talk about. Let's see. Jesus, this device is just acting up. I don't know what it's. Buy new stuff and still ridiculous. I don't think I'm gonna have enough time to play the audio from Court TV because it's a bit winded as well. It's almost 15 minutes long, pertaining to the woman that was found in a septic tank down in Florida. Man, this is messing with my live right now. 2 hours in already, and they're still yapping. Let me start off with Cynthia Cole. Is a lady that was found in her septic tank down in Florida. An African-American male has been arrested for her murder. The two knew each other. He was a handyman, and now there's information coming forward that possibly she was alive, put inside of the tank. This is just absolutely crazy. I'm going to try to pay attention to the trial and also play you this information here too. Thank you for joining me.
For those of you not familiar with the story, here's John Shaman from WPTV, our great affiliate down in West Palm Beach.
Lisa Steiger places a bouquet in front of a sign she left by her neighbor's garage off Skyline Drive in Jensen Beach.
Because I wanted to show my presence of, how much she meant to us in the neighborhood.
The body of that neighbor, 57-year-old Cynthia Cole, was found by investigators in her septic tank Saturday. She'd been missing since February 24th.
She would have loved the flowers and the butterflies. That's how she was. She was just very earthly, down to earth.
A handyman who did yard work for Cole, 34-year-old Keoki Demich, was arrested and charged with her murder.
By his own admission and by witness testimony and other information we have, he was at the house. And based on cumulative evidence, it does appear that she was probably killed soon after getting home.
The sheriff says although Demich was listed as a sex offender in Washington state from an arrest as a teen, he didn't have that designation in Florida because of a change in the law and had been friendly with the victim for years.
He was not on our radar.
An autopsy is yet to be completed, but Cole suffered a number of trauma injuries.
They had a monster machine digging that hole.
Detectives who had stopped by the home last Friday noticed a sewer pipe in the backyard that had a number of screws loose from the cover. An initial check spotted the body, and that led to the weekend excavation.
It just breaks my heart what happened to her. And it's just disrespectful.
Hold on one second, you guys.
I can't believe that somebody would harm her.
Let me see what they're talking about now. Hold on one second. Oh, Lord, this is ridiculous.
Obviously, Mr. Smollett, unfortunately for him, has not been treated like anyone else charged with Class 4 felonies. He's been disadvantaged at every turn, and his jury selection...
Jury in this case the same way I pick a jury in a murder case. I do the questions. I ask the lawyers for input. Tell me what questions you want me to ask. I vet them. And I'm happy to ask the questions that are relevant and helpful.
I understand, Your Honor.
Just the only point I'm trying to make is that I absolutely treated him the same as everybody else. And I didn't distinguish him from a Class 4 offender or potential offender from a person accused of murder.
What kind of animal would you be? Boy, he handled that with a lot of patience.
They're just going back over commentary from the court. I'm going to go ahead and I'm doubling up two different commentaries at the same time. Excuse me.
Attention homeowners, can we use your home to advertise one of our designer metal roofing styles? We need homes of all.
Ooh, Lordy, this is too much.
That somebody would harm her in the way that they did.
We've got some updates tonight regarding the autopsy results. The cause of death has been determined to be homicide, but there are a lot more questions that need to be answered. Let's bring in our guest joining us tonight in Jacksonville, Alabama, professor of forensics at Jacksonville State University, forensic media analyst, and former senior investigator for the Fulton County Medical Examiner's Office. Joseph Scott Morgan is with us. In San Diego, California, retired director of the San Diego Police Department Crime Lab, Jennifer Shen. And joining us tonight by phone in Martin County, Florida, is Sheriff William Snyder from the Martin County's Sheriff's Office. Sheriff, thanks so much for joining us. Great to have you with us tonight. What can you tell us? What's the latest information that we're getting from the medical examiner?
Well, thank you again for having me on your program. Since we spoke earlier this week, the autopsy was completed. Now, there are some results that are still not bad, but the medical examiner is ruling unequivocally that Cynthia had sustained numerous blunt trauma injuries. So those would have consisted of blunt trauma to her face and head, her abdomen, and she also showed signs of asphyxiation and strangulation. And I know the question has been posed, I think, by you is the show open, and I'm getting the same question too. Was she alive when she was placed in that septic tank? The medical examiner is cautioning that she can't be absolutely certain, but she cannot rule it out. There does seem to be at least some evidence that she may have still been breathing when she was placed in that septic tank.
That is horrific. Absolutely horrific. Joseph Scott Morgan, let me ask you about that. What are some of the ways to make that determination if Cynthia Cole was still alive when her killer placed her in that septic tank?
Well, the ME will handle this case just from the trauma that has already previously been discussed relative to the head trauma and obviously trauma to the stomach and this sort of thing. The blunt force trauma, it'll be handled in a manner that you might not imagine in a case like this, but you're going to look into some of the facets related to drowning. And what we look for is in the airway, is there any evidence of any of the debris that might be associated with this septic tank environment that she had inhalated? If it's in her airway, then it possibly extends into the lungs as well. And since there will be solid waste product in that septic tank, as lungs are carefully examined, not just in a gross manner, which means overall without the assistance of microscopy. You can see debris in the lungs there, but when they go down to microscopic level, they'll be able to see little focal areas of deposits in her lung, and that would give you an indication that she had probably at least inhalated some of these substances in this environment. It's not beyond the pale to have somebody that is, say, rendered unconscious. They still have agonal respirations and this sort of thing, mouths open during this environment. They can't do for themselves, they're struggling, and they're still attempting to breathe. So it's by virtue of that you inhalate what's in the environment around you.
Sheriff, how long do you believe she was in that septic tank before you and the rest of the investigators were able to find her?
Well, we know exactly. It was right at 6 days. We know what day she was out with her friends, came home, and by the mountain of evidence now, we've determined that the suspect was there waiting for her, and we know the exact moment we opened the lid and discovered her body. So, yeah, 6 days.
6 days in a septic tank. Jennifer Shen, you're always looking for pieces of evidence in a death investigation, anything to link the victim to the killer. Your thoughts about this type of crime scene? Have you ever dealt with something quite like this, Jen?
No, thankfully I haven't. And kudos to the investigators for finding her. I mean, that's just a product of really careful examination of the crime scene to find clues like that. So what we're always looking for in this kind of scene, like a sort of a body dump scene where her body was dumped into the septic tank, was there anything that was dumped with her that can be connected back to the person that put her there? So did he throw down anything that was his or anything that he had touched or handled? Sometimes it's tools, sometimes it's weapons, sometimes it's a blanket or something that you could analyze forensically and then connect back to the perpetrator. So that is a really important thing in this type of scene, and I'm sure that's what they're doing.
Sheriff, you indicated that you know a lot about this case. Investigators have really put all the pieces together here. You mentioned that you believe he was waiting for Cynthia when she was returning. I think she was in town that night. Do you know exactly where this attack took place?
We're still waiting on some analysis of what we think is blood from the house. We use alternate light sourcing and luminol, which is a way to spray a substance in a dark room, and it'll fluoresce if it hits organic material. We think we have drag marks in there. There was no obvious sign of struggle inside the house. So oftentimes and your guests have all seen it, when you have a large male, he was 6'2", a strapping young man. She was a diminutive woman at best, a small, thin woman in good shape. Wouldn't have taken much to render her unconscious, and there didn't necessarily have to be a lot of blood in that house. There was evidence that he had worked to clean up something, but 6 days time was not our friend in this case. There was a concentrated cleaning fluids that we used to clean up the floor. We still found evidence. We're waiting. We're pretty sure it's going to be blood. So the answer is it probably happened in the house. It probably was an ambush attack. She did not see what was coming, and she would not have had a chance in that fight.
Jen Shen, I want to go back to you. What would you be looking for inside that home?
Well, evidence of cleanup. People think they can clean up a bloody crime scene and we can't find it. And, luminol is a great tool there. It reacts with the invisible traces of blood at a crime scene and fluoresces in the dark. And so you can see, and not only can you find blood that way, but you can also see patterns that way. So drag marks are a great example. Sometimes we can see void patterns where there's blood all around an area, but there's one space that has no blood in it. And you can kind of recreate the scene if there's enough blood by using tools like that. So we're going to be looking for any sign of him in the house as well. I mean, if he's not a person that's supposed to be in our house, it's a pretty violent act, it sounds like, for him not to have left any clues of any kind And sometimes amongst all the blood that's at a scene, there'll be 1 or 2 drops that belong to the perpetrator. And that always is, that's always very, very important evidence. So you're looking for what happened to her with this, and you're also looking for evidence of him in the scene, whatever that might be.
Joseph Scott Morgan, how would you approach the issue of trying to figure out the source of the blunt force trauma? What was she struck with? And perhaps the strangulation that may have taken place as well. How do you figure all that out?
Well, I can tell you, at least to a marginal degree, there's going to be some compromise of the tissue because septic tank is an aerobic environment, which means that to a certain degree, the process of decomposition will be sped up a bit in this environment because, let's face it, that's kind of the purpose of the septic tank. And so in that, the pathologist will be kind of at a disadvantage, but not too terribly. If there's a head strike, say for instance, and you've got an underlying skull fracture, you can still pick up on patterns. Maybe perhaps if it's a depressed skull fracture, maybe there's a pattern relative to that. And still to a certain degree, you can pick up on patterns on the skin, but you have to be very, very careful in these kinds of circumstances because the body becomes progressively more fragile as you go down this time range that the sheriff has mentioned. We're talking 6 days down range in an aerobic environment where she's already got possibly open injuries already, which is going to promote decomposition to a great degree around this focal areas of insult.
Sheriff, let me ask you, someone who is capable of doing what he's accused of, does that make you think that there may be some other victims out there that either haven't been found or maybe cases?
We're back in court, I believe. Jussie Smollett. I'm intertwining stories. Sorry about that. All these are very winded. Sorry. Time for the victim impact statement. His family members will now speak before the court before sentencing. Thank you for joining me. This is Everyday Shenanigans. Thank you for following the content, everybody, and bearing with me. It is very winded, going into hour number 2 now. Sorry about that. Let me see if I can. This is turned on.
On behalf of Stephen Kane, Deputy Corporation Counsel, and David O'Brien, Superintendent, Chicago Police Department. As the jury concluded, Mr. Smollett falsely reported to the Chicago Police Department that he was a victim of a hate crime. Specifically, Mr. Smollett told the CPD that 2 people attacked him, placed a rope around his neck, poured a chemical on him, and called him homophobic and racist slurs, and stated that this is, quote, MAGA country, end quote. Mr. Smollett claimed he did not know his attackers, but that one of them was white-skinned. A massive investigation ensued, costing the city and its residents well over $100,000. For the following weeks, more than 30 Chicago police officers and detectives investigated Mr. Smollett's report by conducting witness interviews, reviewing over 1,500 hours of surveillance video, in-car camera videos from taxis collected by detectives, as well as other evidence. These same detectives also gathered documentary evidence, including rideshare records, store receipts, store videos, and knocked on doors, going door to door during the polar vortex, one of the coldest periods in Chicago history. During this period, the detectives and police officers worked around the clock, amassing over 1,000 hours of overtime in an effort to solve what in the beginning was thought to be a horrible hate crime. The overwhelming stress and fatigue that was put on the Chicago officers who were involved in the case was immense. While the city can address the financial costs of Mr. Smollett's false report and the investigation that ensued, a cost that can never be measured, is the harm caused by reducing the likelihood of actual victims of hate crimes willing to report these crimes. In CPD's experience, Hate crime victims are frequently hesitant to come forward and cooperate in police investigations out of fear that they will not be believed or they will be targeted for additional crimes. Members of these communities often feel marginalized even before suffering the indignity of the hate crime. When crimes are not reported, the perpetrator is not punished and remains free to commit other crimes, endangering public safety. This is particularly problematic in the context of hate crime because these crimes harm not only the individual victim, but also others who share the victim's trait, creating fear in the broader community. Falsely reporting hate crime have a tremendous chilling effect on the real victims. Indeed, Mr. Smollett himself acknowledged that, quote, "You do a disservice when you lie about things like this," end quote. The financial cost of investigating Mr. Smollett's false hate crime report was significant. CPD spent 1,426 hours in regular shift time investigating his false reports at a cost of $67,734 in employee time. CPD also spent 1,837 overtime hours investigating Mr. Smollett's false report, costing the city $130,106. A spreadsheet calculating these expenditures is attached as Exhibit A. Your Honor, we respectfully submit that restitution for the city is warranted here. Illinois law authorizes restitution to compensate the victim of a crime for out-of-pocket expenses, damages, losses, or injuries found to have been proximately caused by the conduct of the defendant. Government victims may recover restitution for expenses that go beyond the normal cost of investigating crime. That is exactly what happened here. The city is a victim of Mr. Smollett's crime because of his false report caused CPD to expend scarce resources that could have been devoted to solving actual crimes, increasing public safety. The city is not seeking restitution for the regular salaries of the officers involved, but CPD's overtime expenses that go beyond the normal cost of investigating crime and are thus recoverable. A restitution award as part of Mr. Smollett's criminal sentence would enable the city to avoid these costs and delays. For these reasons, we respectfully request that you seek restitution for the city in the amount of $130,106 as part of Mr. Smollett's sentence. Sincerely, Stephen J. Kane, Deputy Corporation Counsel, City of Chicago. David O. Brown, Superintendent, Chicago Police Department. Your Honor, a copy of the full letter has been made a part of the record.
Thanks, Mr. Procedure. Thank you. Does that conclude your evidence and aggravation?
Yes, Your Honor.
Okay. Does the defense have evidence, witnesses, or documents that they wish to present in mitigation?
Yes, Your Honor.
Sure, you may proceed, Mr. Allen.
Thank you.
The judge please call the witness Rich Daniels.
Rich Daniels, sir, please step up right here.
Sorry. I didn't know it was this long, you guys. I'm so sorry. I should have known better. I should have just waited till the information and then brought it to you guys. Thank you for joining me. Yes, we are in good company.
Thank you very much, Judge.
Thank you, sweetheart. Thank
Sir, in a
you.
loud, clear voice, would you please introduce yourself, state your first and last name, and spell your last name?
Sure, my name is Richard Daniels. My last name is Daniels. And I'm sorry, what else are you asking?
Sorry. Mr. Daniels, how old are you?
Oh, really?
Yes, sir.
I'm 61 years old.
All right. And are you familiar with a person by the name of Jussie Smollett?
Yes, I am.
How are you familiar with him?
I met Jussie 8 years ago this month when I was the music director of the television show Empire, for which I was the on-camera music person for all 102 episodes in all 6 seasons.
So in what capacity did you know Mr. Smollett while working on Empire?
Jussie was the breakout music star on the show, and as the music director for the on-camera work, I worked with him closely, daily, for many years of the show, as helping to support him in terms of his role on the show.
All right. Now, in terms of his role in the show musically, how did you help support him in that way?
We put musicians on camera around him in the 6 seasons that we did Empire. We put around Jussie and other cast members and guest artists, musicians from the community. So 400 different musicians and vocalists appeared on that show from the local Chicago community over the 6 seasons we had the show, many of which performed with Jussie, and many of which he embraced dearly as friends over that period of time.
Did Mr. Smollett also have any hand in making sure, securing any of these musical artists?
He would sometimes voice opinions and give me approval or tell me what he's looking for. So, of course, there was interaction that way. And through that process, we became very good friends.
So outside of the show, you said you became very good friends. What type of things would you say you did with Mr. Smollett?
I was very active, and I continue to be active in the world of nonprofits in Chicago, supporting various things. And so I would tell Jussie about certain things that we were active with. And as a celebrity, I would say it would be very meaningful if you might consider participating and donating your time and your talent, which he willingly did on many occasions. And it was always a very meaningful experience for those who saw him and interacted with him, and meaningful for those of us who brought him out.
Now, Mr. Daniels, I'm going to ask you briefly to, if you can, go through just a few of these nonprofits or any of them. I know that there's one that was relevant with the Boys and Girls Clubs of America.
That was a meeting we had that never went beyond the meeting stages. But the one that was really relevant was a school on the west side of Chicago, a grade school. And it has 505 African-American children. I believe it's the largest population of African-American children in the grade school system in America. That's what they talk about. Magnificent school. I was brought in a few years prior to Jussie coming in, asking to support it in various ways. And their mission was so great, it was easy to jump in. I asked Jussie if he'd come over. He willingly said yes. And for me, it was an extraordinary life experience because we didn't tell the children who was coming that day. It also led me to believe of what a huge show Empire had become in the African-American community. We didn't tell the children he was coming to their classrooms that day. Each classroom we walked into with Jussie, the children jumped up with joy, ran to him, hugged him, cried with him. It was an amazing experience. It was cathartic to witness it and to see it happen because the impact he had as a celebrity and as this loving, wonderful young man was dramatic. It was really quite something. I was very taken by it, as were those who were with me that day, as were the people who were administrators at the facility. And that was one example of the many that he participated in, giving his time and his talent. He is a very charismatic young man. He's a very loving and caring young man. And, he was generous, and he was thoughtful, he was kind, funny, and intelligent, and I just think the world of him.
Yes. She'll lay it on thick like the lawyer did.
Energy, charisma, all these beautiful things that you just stated about Mr. Smollett that he willingly and abundantly gives. Would you say that he gives anything else of himself or from himself to communities or anybody else around him?
I know of charitable contributions he's made in large sums of money, and I know of large projects he supported financially in addition to his time and talent. So he covered all the bases of time, treasure, and talent in terms of his giving and his willing to participate in the community. And it was always with a loving heart. It was always with a willingness to do good and to give back to what he had been given. He knew he was a lucky young man. This show Empire, this was catching lightning in a bottle for all of us who were able to be on it. There were 593 scripted television shows made in America last year. 593. I think
he's landing on thick, is he not?
And there were 593. So
wow.
Everything.
Children, African-American kids.
Empire was one of the 3% of all television shows to get beyond 5 seasons. Doesn't happen. We think of shows that have long lives to them, that's fine. But the number of shows that have long lives, very few and far between. So Jussie had an appreciation for that, what he was given, as did all of us on that show. It was a game changer for Chicago. The community embraced that show in huge ways. The first episode of season 2 had 29 million viewers. Those are major sporting event numbers. And that made a huge presence.
I'm getting a headache.
In the community, both in television and in the community at large.
Would you say that based on all of Mr. Smollett's contributions, that he was absolutely a pivotal part in the show's success?
Oh, he was. He was the music star of the show. I'm sure that Terrence and Taraj and anybody else would tell you the same thing. Jussie was the music star of the show. everyone else participated in it, but he was the day in, day out go-to music guy. He was our breakout music star on the show.
Now, Mr. Daniels, would you be willing and able to support Mr. Smollett if he were given a chance at a term of probation in this matter?
Of course. It's part of my daily activities in Chicago, the thing I'm most proud of.
You don't believe that there would be any issues that Mr. Smollett would ever exhibit on a period of probation?
None that I would have ever seen or ever thought of.
And one moment, Judge.
Now, what is she asking you?
Is that okay? Take a sip.
Yes, sir.
This man cannot speak for Jussie Smollett because Smollett is a liar. He only knows him as working on the show. He doesn't really know him. That's obvious. Nobody knew Jussie Smollett unless somebody's dealt with him and been lied on. Other than that, you don't know people. He's a fraud.
Just going back briefly, Mr. Daniels, of all of the incredible...
And this lawyer speaking, she's African-American, if you didn't know.
You said Mr. Smollett gave himself to willingly. Those were not required of Mr. Smollett in any way, were they?
They were not.
Hey, Bridget.
Neither by the show or any agency that you're aware of.
No, absolutely.
Oh, Lord. This is sickening. This is maddening, but this is the law. This is how it happens in court. This is what happens in court.
So you believe that in addition to any of the, again, services that Mr. Smollett gives willingly of himself, that if he were given a term of either probation or some kind of community service, would you be willing or able to either supervise that or make sure that he would be compliant and continue to give himself to community service and service of others?
Absolutely. Happy to.
Thank you, Mr. Daniels.
They're asking this guy to be in compliance with supervision for probation.
Thank you.
Call your next witness.
No, he needs to work with somebody he doesn't know, never met, never dealt with. How about going out to the Parks and Recreation to pick up trash? Not helping children. No.
Please raise your right hand. You swear to tell the truth, the whole truth, and
No.
nothing but the truth, so help
Probation, talking to kids and all that? No.
Try to keep your voice up.
Do hard labor.
Take your mask off if you like. You want to
Pick up trash.
Both masks. Mr. Allen, you may depart. Thank you.
May I please state your name?
Sharon Gelman,
Spell your first and last name.
Crazy.
SharonGelman.
I know my mother would kill me for this question, but I'm going to have to ask how old are you?
62.
And what do you do for work?
Well, now I'm a writer, editor, and a nonprofit consultant, but for many years I ran a nonprofit called Artists for a New South Africa.
Without telling me your address or anything, what state do you live in?
I now reside in Maryland in the Washington, D.C. area.
And did you fly in for this specific purpose?
I did.
And why specifically did you fly in for this purpose?
Jussie's like family to me. I've known him for well over half of his life and a good chunk of my own. And I came because I was hoping that I could help people see the Jussie that I know.
So do you remember around the time you first met Jussie?
I met him in 1999.
That's very specific, okay. And why does that stick out, 1999 when you met him?
It was we were producing an event. It was the 10th anniversary of my organization's existence. And it was the 5th anniversary of South Africa's new democracy. And we were doing a specific portion of the event. Desmond Tutu was our keynote speaker and ambassadors and Sidney Poitier. We were doing a specific portion which was about the role of young people in the struggle against apartheid. And I asked the artists who were founders and our board members who would be like a wonderful young artist, someone with great talent and great to include, and they all suggested Journey Smollett, and it was in that context that I met Jussie, who at that time was doing was representing her, working on her behalf.
So back in '99, Jussie would have been a younger man.
He was 16.
Right?
I was gonna say he was a child. Doesn't count.
Well, he was when I called and spoke to him. We wrote a letter asking Journey to participate, and I got a very professional phone call back from someone named Jussie, and I was very impressed with him. And he said, I do public relations for Journey. And then he came into the office to meet me, and in walked this like utterly beautiful young man. And I was like, oh my God, you're a baby. And that was when I learned he was Journey's brother.
Did you get the feeling back then in '99 that Jussie understood the significance of the event that he was attending in South Africa?
Yeah, well, first of all, the whole Smollett family is very charitably and politically engaged. And Jussie and Journey were very excited to be involved. I mean, I think Jussie, because being raised up and exposed to the arts and entertainment community from a very, very young age as little children, they understood the power that that fame confers, and they also understood the responsibility. So they loved the idea of using Journey's very baby, embryonic star power to do something good in the world.
So after '99, did you continue to have a relationship with Jussie?
Yes, Journey and Jussie and Jake and Jazz and Janet, the whole J family, would often come in and volunteer. They would stuff envelopes. I mean, they were like a all-service vehicle that, it's like, do you need us on stage? Do you need us sweeping the floor? They would just do all kinds of things. And then, gosh, I think it was around 2006. It might have been late 2005. We needed another staff person. We were a tiny organization, and I hired Jussie then, and he came and worked for me full time for 4 years in the office.
What was Jussie's role after he was hired?
Well, he started off as my administrative assistant, and he will forgive me, I hope, by saying that Jussie has many talents. Paperwork is not really one of them, but he was so good with the staff and with our volunteers and with our interns. I mean, we were a tiny organization, and we did big things, and we depended on the largesse, not only of our celebrity members, but also of students and grassroots community folks who came in. And Jussie just was really stellar at making everyone involved, from the highest and mightiest and most world-renowned to, the kids we were working with in the inner city, making them feel special and welcome. And we worked really hard, and he was one of those people who had the rare gift of making hard work fun. So he really played a very, very pivotal role, and I promoted him pretty quickly. He became the coordinator and manager of our charity auctions, and then we produced an audiobook in honor of we announced it on Mr. Mandela's 90th birthday, and we released it on its 91st birthday with a major publisher and 26 celebrities from all over the world, renowned people of all backgrounds. And Jussie, was very involved in coordinating that. And as I said, he was willing to do anything. He was willing to, go pick people up. He was a good photographer, so he would document the sessions. Anything that needed doing, Jussie was willing to do it.
I got a little starstruck when I heard Nelson Mandela and Desmond Tutu. So what exactly?
Oh my goodness, this is ridiculous.
Well, we were founded in 1989.
Hours. This has been going on all day.
And brought together a bunch of people. It was during the height. We didn't realize then that it was towards the end of apartheid, but it was the height of still continued conflict. And she had been with the Congressional Black Caucus, and they were talking about people needed to go back and work in their communities. So Alfrey came back and organized her community, and I got involved. I think I showed up at the third meeting. I heard about it, and I never left. We raised money. We raised awareness. We over our years, we raised and granted $9 million to frontline groups in South Africa doing African-based, African-led organizations doing AIDS work, to democratic development, youth education, economic development, and we harnessed the ability of our members to raise awareness about HIV/AIDS prevention and treatment, about the voting process, both in South Africa and in the U.S. We always tried to match what we were doing in South Africa with a related issue locally, either in Los Angeles or in the United States, so that we weren't, being those people who care a whole lot about something thousands of miles away, but don't care about the community that you can drive to or live in.
So during Jussie's time working there, I heard that you put him in charge of charitable contributions, which
charitable auctions.
Which seems like a very important job.
Chair, stop it.
He did. I mean, that was one of the things he did. But for
He could sing to them inmates.
He would contact our.
He could sing an R. Kelly song. I believe I can fly.
Celebrity members.
I'm dead.
And others of resources, and ask for things that we could either auction off live or online. So live at a big event or online. And so it would be everything from, I think our two highest money-making things, or our three, were Jillian Anderson, who was a board member, gave us passes to the wrap party for the final season of X-Files. Jackson Brown let us auction off, I think it was, he let us auction off someone coming and working with him in a studio to record their song, which ended up being a really long process because the person wasn't a musician, but we earned a lot of charity dollars in the process. And then I think our other highest generating item.
So older lady testifying that worked with him when he was a teenager, 16 years of age. That's a long time ago. And more than likely, he was a liar then.
From 1999 to 2010, since he worked those 4 years. Can you explain the growth in his character you observed during that time?
Well, Jussie, I mean, obviously he went from being a very young,
behave, Marie,
adolescent to an adult. I mean, I would say his character was the same. He was a very open-hearted, hardworking, pure-hearted person. I mean, he didn't have a car. He rode a bus 1 hour each way to our office, and sometimes I would drive him partway home. And he would always be like, no, I'm fine, I don't mind. It's like he was like, I'm so excited to get up every morning and do something to make the world a better place. I mean, he was like evangelical in that way of really believing in the cause.
Good question.
And he got paid very little. We wanted all of our money to go to the front lines, but nonetheless, he got paid really little.
That's where the lying starts. As a child, preteen.
For that, he would be like, no, I'm so like, I feel so excited and lucky to be part of this. And we became friends. I mean, I loved all my employees and I believed in them, but Jussie and I also became real friends.
So after 2010, you kept in contact with Jussie?
Oh, absolutely, regularly.
In what way?
Well, sometimes it would be him wanting to figure out a way to make a difference. So he had witnessed all these people, Sam Jackson, Denzel Washington, Sidney Poitier, who could use their position to benefit others. And so that was such a deep part of who Jussie was. And he also understood it from helping those people to do that work. So sometimes he would call. I remember him calling me right when the story broke about the water in Flint, Michigan, and he was literally sobbing on the phone, just going like, I can't believe what's going on, and I really want to make a difference, and here's what I'm sort of thinking of, and would you help me figure out if it's the right way to go? And I want to give money, but I also want to go and bring supplies, but I also just want to show up for people, and I wanted, he was always trying to figure out how to do what he could do best. And a lot of what he did in those ways, I mean, he understood the power of standing up for people, and that the TV cameras would follow, and that maybe others would follow his example. But he also did a lot of what he did during that time anonymously and quietly, but he still did the due diligence of figuring out which group is good and how do you figure that out. And I'm going to call people I know and do my research so that my dollars are well spent and are making a real difference.
Sure. So Jussie went from taking a bus to your office to becoming a worldwide phenomenon on a TV show. Did you notice any change in his personality when he gained that phenomenal success?
Not really. I mean, he was still Jussie. He was funny and sweet, and he was so effervescent about this magical thing that had happened to him. And I think for all of us who worked with him at ANSA, Artists for New South Africa, whether board members we were all so thrilled for him. It was like, we all knew he was talented. We had him perform at a couple of our events once he started performing musically, and we were all fans. And but he wore it well. He wore his fame responsibly, and he understood sort of the requirements that come with that kind of position if you want to be a good decent person living in the world.
So if Jussie was given a period of probation in this case, would you be willing to help supervise to make sure that that probation period goes fantastic?
Absolutely. I mean, I call on Jussie. I've called on Jussie to help me on things in these years after he's worked for me. I mean, most recently, in the middle of all of this, I was helping with an auction for Desmond Tutu's 90th, which ended up being his final birthday before he died. And I called Jussie and asked for his help. And I was like, I'm sorry to do this while you're going through all this. And he's like, no, God, this is like, thank you. This gives me something else to think about. And he really went out of his way, bent over backwards to try and get some contributions. So I would be honored and would take it very seriously if to help Jussie continue to be a really deeply contributing member to society.
So true. Name dropping. Exactly. Desmond Tutu. Oh, give me a break. Oh, feet gonna swell listening to this. Golly. This is daunting. I'm so sorry. I had no idea if this was going to run as long as it did. So I'm sorry about that. His lawyers already talked junk to the judge. Not good. Not good at all. 4.5 hours now. This nonsense. She works with a nonprofit. This older lady. Caucasian female speaking. 62 years old, I believe. Okay. 61, 62. 2 people have testified on his behalf as witnesses, and they all were 61, 62 years of age. So far, nobody young has testified as a victim advocate for him.
My family earlier this week about us passing notes and prayer sessions.
I believe this is his brother speaking now.
My brother right here is on trial. While this might just be a level 4 felony to a lot of people, under the circumstances, this is felt like the reincarnation of Al Capone's trial, okay? To be honest. And it's not your fault. I'm not trying to say it's your fault, I'm saying, but the way that this has been, so that's probably the reason he's still sharing notes and doing prayer sessions. My mom's 69.
He has a lot of nerve to be comparing this trial to Al Capone. Al Capone's been dead many years. I think he meant to say John Gotti. Come on, stop this. This is foolishness.
You know what I'm going to say. I strongly believe in my brother's innocence. But I'm not going to try to relitigate the issues in the case today. Your Honor, I come before you humbly to request...
So basically he's saying this is a witch hunt for his brother.
Please remember that we are currently living in a time in which we are enduring a vicious pandemic...
Oh, the judge is up there.
...economic uncertainty, major conflict in Eastern Europe, and global paradigm shifts taking place everywhere. As human beings, we are collectively worn down. But Jussie Smollett is not at the source of the socio-economic and political problems on Earth. Quite the contrary, he is a man who has been a beacon of hope, charity, and philanthropy to his nation and to his community. He has made real efforts in his lifetime to promote equality and love among all of humanity. He has expressed strong political views and has stood against injustice wherever he thinks it may lie. His criticism of powerful individuals, organizations, and practices does not make him a bad person, or someone who should be punished. It simply makes him an American. I'm sure that Mr. Dan Webb was once on former President Ronald Reagan's radar for his criticism during the Iran-Contra prosecutions, all right? But paying up to powers and authorities in America is part of what makes us Americans. And he turned out to have a pretty successful career after he stood up to power. Jussie does not have malice or hatred toward anyone, and it is truly unfortunate that his reputation has received so many negative connotations, and he has never received the benefit of the doubt or a proper presumption of innocence. And even though I completely disagree
That's a lie.
with the decision in this case,
A lot of us thought that he was hurt when this first started, the very first time it got out. We had no reason to believe it was a hoax.
Continue.
I'm biased.
So that's bullshit.
I am 5 years older than he is, and I can remember him at infancy. He has always been a loyal, loving, and creative human being. He is not a threat to the people of Illinois. And in my humble opinion, Jussie is completely innocent, but even for those, once again, who think he is guilty, the crime he has been accused of is not even considered a felony in most states. Furthermore, here in Illinois and in Cook County, disorderly conduct is oftentimes not even prosecuted, and charges are frequently...
Who cares? So what? It's a first for everything.
...would send the wrong message, especially in a time in which we as a nation have expressed in a bipartisan plurality the desire to see real criminal justice reform and an end to unnecessary...
He's downplaying the crime itself because it's not a felony in certain places. Doesn't matter.
As a nation that calls itself, we cannot do so while continuing to incarcerate more nonviolent offenders than any other nation in the world. Mass incarceration is also an unnecessary burden to the taxpayers, to law enforcement, and it is simply unjust and wrong.
Well, a lot of people deserve to be in prison, sir.
That Jussie is guilty once again and needs more punishment. I would also ask you to consider the gut-wrenching and stomach-turning punishment he has already experienced for the last 3 years. The TV show that he poured so much labor and commitment into making a success was ripped away from him even before he was criminally tried. The fact is, the overwhelming majority of mass and online media reporting in early 2019 resulted in a premature assumption of guilt, and the court of public opinion had already convicted Jussie in early 2019. For the last 3 years, he has had to live in anxiety and in a certain kind of pseudo form of house arrest. As a public figure, he has had to deal with public scorn and the real...
Well, he wasn't on house arrest.
Being an accused celebrity.
He chose that. That's his choice.
In essence, quarantining almost a year before the COVID-19 pandemic even began. Now, we all know the Sixth Amendment of the U.S. Constitution guarantees the right to a speedy trial. In my
Yes, they've had a break.
It's unfathomable for me to stand here in March of 2022, pleading with Your Honor not to give my brother jail time for a low-level offense that is alleged to have been committed in early 2019. For those who believe he is guilty, once again, trust me when I say that the punishment he has already received has far exceeded the actual alleged offense that
His brother ought to be ashamed of himself. Jussie chose all of this. He didn't have to do it.
In my opinion, you don't restore public trust by demonstrating to the public that a level 4 felony, which once again is not even what he's accused of, not even a felony charge in most states in America, by giving him a stiff sentence, which includes jail time. That's not restoring public trust. That's in my opinion, right? And if you were to go 5 miles in any direction in this area from this courthouse and talk to people in the community, you're not going to say it. They're not going to tell you, oh yeah, we restored the public trust because Jussie Smollett went to jail. Trust me, it's not going to happen. All right? This is not restoring public trust. All right? We are dealing with a lot of things in the world right now, and sending him to jail would not be restoring public trust. So please also keep in mind that, like myself, many people view this case as nothing more than a he said, she said kind of case, right? With no evidence that warranted his conviction in the first place. With that in mind, Your Honor, I am humbly requesting that your sentencing of my brother.
He said, she said.
Incarceration. I myself and my entire family will be eternally grateful. I thank you for your time.
The brother's cocky, just like Jussie. They're definitely related. You can tell the people how the judge should render a decision of a sentencing. If that's the case, you don't think he should have been arrested, of course. But they found evidence that this was a hoax. That's why they brought forth charges, investigated again.
Mr. Allen, how about a chair? Would that be
That's
helpful?
it.
I need a mic. She's the boss. She's got to tell me where to go.
I want to be heard.
Fair enough.
Killer B, I've done a video about her, Miss Papini. Yes.
Thank you so much. Okay. Good to be here. Okay. I thank you for this opportunity to allow me to make this statement. My name is Molly Smollett, and I am 92 years old. I have lived in New Mexico for over 25 years, but I am originally from New York, where I was a film editor. I am the proud grandmother of Jussie and his siblings. I felt compelled to come and tell you that the Jussie I know and love does not match up with the media's betrayal of him. And I'm talking to you guys. You haven't done a good job on investigative reporting. I've worked on documentaries. I know what it is. I've gone through the McCarthy period. I marched with Martin Luther King and marched on Washington, and I'm here now. And so you got to do better. I challenge you to do more investigative reporting. Jussie himself, as you have heard from the testimonials, is a very gentle, kind, and generous.
This is his grandmother, Caucasian lady.
Which translates in giving of himself. Jussie has always been active in the pressing issues facing our communities, such as HIV, AIDS, voting rights, and other urgent social problems in America. One Christmas, he went to Flint, Michigan to entertain children who were living with lead poisoning from their drinking water. What the media may not know is that Jussie is what I call a justice warrior. He has been active against injustice all his life, as his mother has, who is an incredible rock for her children. And as my son, their father, who sadly passed away from cancer 7 years ago, only in his 50s. And I know in my heart that my son, Jussie's father, would have wanted me to come here to tell you who the real Jussie is. I also have fought against injustice forever, and I feel it's in our DNA. I attribute this to being Jewish and the persecution of my ancestors. The Hebrew words tikkun olam means to repair the world, and that's what I do, and that's what Jussie does. I will end by saying that Jussie is loved and respected by all who know him. And I ask you, the judge, not to send him to prison. If you do, send me along with him, okay? And I thank you for letting me talk. Thank you so much.
Wow.
Thank you all. It's nice to be in Chicago.
She's telling the people that didn't investigate, investigators didn't do their job. She's used the Jewish card.
Of course, addressing the media, talking about her own background.
So much. Okay. Thank you.
Yeah, this runs deep in their family. Narcissistic behavior, narcissistic brother and grandmother. Wow, the mother's mother, I believe. Father's mother, I think. I don't know. I kept thinking their mother was black. I can't remember. It doesn't matter. Wow. Oh, Jussie, is you crying?
Judge, not at this time. I believe, I'm just checking this out. Okay, no, Judge, just a statement to me.
Okay. All right, I've heard
Yes,
evidence
T.
and aggravation, evidence and mitigation. I'll now entertain arguments in aggravation and mitigation, starting with the Office of Special Prosecutor.
I'm sorry, Your Honor. Sorry. He wants to.
Yes, okay. I know what you're talking about. I have received numerous letters on behalf of Mr. Smollett. Some of them as recent as today, this morning. And I think it's only fair to publish and spread a record who those letters are from. Generally, they're all asking for mercy. They all know him in different capacities. They're strongly advocating for him. But you can tell me who those letters are from. And I think the special prosecutors also received the same letters that I've received.
Yes, Your Honor.
And if you want to paraphrase a little bit from the letters, Mr. Allen, you're welcome.
Poor judge. I feel sorry for the judge.
The first letter here is from the organization Black Lives Matter. Dear Judge Lynn, Black Lives Matter stands in strong support of an alternative to incarceration sentence for Jussie Smollett. We applaud your long-held practice of imposing alternative to incarceration sentences for virtually all Class 4 felons, such as Mr. Smollett's, and encourage you to continue this practice in this case. We know that second chance probation, regular probation, and deferred prosecution are all options. As we contemplate what creates a truly safe world, we know that Mrs. Smollett's case involves no drugs, no theft, no sex, no property damage, and no physical injury to anyone other than the defendant. Despite the attention paid to it by the media, at its heart, this case involves a low-level, non-violent offense. We urge the court to keep this truth in mind when sentencing Mr. Smollett. We know that the cost that will be expended to met out the sentence involving jail time will be much better used providing much-needed community service. We first came to know Mr. Smollett long before Black Lives Matter's growth into the largest racial and social justice movement in global history. Mr. Smollett has an extensive history in civil rights advocacy and philanthropy. Mr. Smollett personally donated more than $500,000 to Black organizations and gave $125,000 in proceeds from his music tour to organizations working for Black, LGBTQ+, and women's rights, including Black AIDS Institute, which provides high-quality, direct HIV services to Black people, Flint Kids Fund, which funds programs aimed to address and mitigate the impact of lead poisoning and trauma suffered by many children in Flint, Michigan, the Trayvon Martin Foundation, whose main purpose is to provide emotional and financial support to families who have lost their child to gun violence, and Know Your Rights Camp, whose mission is to advance the liberation and well-being of Black and Brown communities through education, self-empowerment, mass mobilization, and the creation of new systems to elevate the next generation of change leaders. In 2018, after learning that Bennett College, an all-women's HBCU, was on the brink of losing its accreditation, Mr. Smollett and his brother helped the institution raise the funds needed to retain accreditation. In fact, although the college needed only $5 million, Mr. Smollett and his brother led a campaign that raised $8 million. Beyond his financial contributions, Mr. Smollett has been a fixture in civil rights organizing. We have marched alongside Jussie in fights for healthcare, to draw attention and resources to the AIDS epidemic, for women's rights, to protect the sanctity of families, and in peace walks. Our relationship with Jussie goes back to the early years of Black Lives Matter, or at least 2016. And has continued. Despite his struggles with this case, most recently we sat with Mr. Smollett during the anniversary of Trayvon Martin in February 2022, where he flew to Miami to serve as a loving face and the crowd of support families whose loved ones were stolen by police and or vigilantes with violence. In short, Mrs. Smollett has demonstrated a long-standing commitment to helping others. Incarcerating Mrs. Smollett will be solely punitive in nature. Mrs. Smollett does not pose a threat to anyone. Thus, we respectfully request that this court impose a sentence that is an alternative to incarceration, and ask sincerely Melina Abdullah, PhD, the director of Black Lives Matter Grassroots. Also have a letter here from Latanya and Samuel L. Jackson. It's very short, so check.
The judge was nice enough to let the public hear these letters from civilians out here. Black Lives Matter rep and some other person are about to read. The judge didn't have to let the person read this off. So he's being kind enough to let the public hear others' opinions about Jussie Smollett's guilt or innocence.
I write to you today at
Sad.
mercy as you sentence Jussie Smollett.
Very disappointed with this representative for Black Lives Matter.
As you seek to make decisions which take into account the crime and the punishment. It is in respect of knowing this that I humbly implore you to please find an alternative to incarceration for Jussie Smollett. It is my understanding that Jussie was convicted of Class 4 disorderly conduct, which, to my understanding, people convicted of this offense historically are sentenced to various alternatives to incarceration. My husband, actor Samuel Jackson, and I have known Jussie since he was living down the street from us in New York City. We watched him grow from a child.
I'm pissed. Oh my goodness, come on.
To a responsible teenager who, becoming aware of the inequities suffered by some people in life, became an energetic volunteer helping anyone who was working to alleviate those inequities. Additionally, as a young man, we have worked side by side with Jussie and organizations committed to stopping the HIV/AIDS epidemic in America, as well as dispensing aid to Africa and Israel. Jussie has used his celebrity to impact community outreach work, such as providing water during the Flint, Michigan crisis. We have often broken bread with this young man as we have discussed the right and wrong ways to live. Jussie comes from a family whom we are proud to know intimately, and who we stand ready to provide the support and monitoring assistance that can provide for him in an alternative to probation scenario. Jussie has no prior criminal record and has never been violent. It is incredulous to Sam and to me that this entire criminal situation even exists. Jussie has already suffered a great deal of punishment, as this situation has destroyed his existing career and has impugned his reputation. Please, Judge Land, in God's name, please save this young man and allow him to be of service. Jussie Smollett is worth the risk and the investment. Respectfully, Latanya Jackson and Samuel L. Jackson. And we have more now.
Mr. Lewis, the judge.
Judge, if you'll indulge me for a moment, I'd like to read a letter from the Rainbow Push Coalition.
Oh, Lord, not the Rainbow Push. Damn. Jussie Jackson. Damn, Jussie, really? Oh, man. You all need to stop this.
Someone who has known Jussie Smollett for over 20 years. I know him to have a strong family background. He is a loving and caring person. I am familiar with his commitment to community service. It is important to him to use his gifts to support the needs of others. Jussie was raised in a strong and very close-knit family. I urge you to consider several moral issues as you weigh sentencing options. Jussie has no prior felony convictions. He has a history of community
hours of nothing. This is just hour for hour for hour.
Of his time, talent, and treasury. He has sustained a significant loss of income prior to being convicted of any crime.
That's his choice.
Based on the very public nature of the charges and the trial, Jussie has lost countless career opportunities. I have served as a citizen devoted to having a positive impact on the lives of young men and women in the city of Chicago since 1968. In pursuit of that mission, I visited the Cook County Jail and several Illinois prisons every year since Operation Breadbasket launched. I have seen firsthand the disastrous impact jail has on far too many young people of color, especially young African American men, who often see a complete loss of hope in their situations. Since this case involves the alleged actions of a very visible public figure, it presents a unique opportunity to send a message to millions of young Black and brown men that the system cares for them. This highly publicized Class 4 felony case can be utilized as a positive teaching moment about how the criminal justice system can work to benefit all in our society. I appeal to you in the spirit of righteousness to consider the impact America's criminal justice system has on young Black males who struggle every day to survive the streets of urban America. We have an obligation as a society to favor restorative justice rather than retributive justice. Jussie Smollett was convicted of a Class 4 felony, the least severe category of felony in Illinois. A well-established practice in Cook County is to sentence Class 4 disorderly conduct cases to incarceration alternatives. Such alternatives might include second chance probation, regular probation, or deferred prosecution. Additionally, an important consideration in sentencing is the potential for recidivism. Jussie Smollett's lack of felony criminal record, as well as many positive contributions to society, demonstrates that he poses no risk for recidivism. Jussie has a long track record of being deeply engaged and contributing citizen who is committed to helping the most vulnerable in our society, whether persons living with HIV/AIDS and children orphaned by the disease, or children whose health was damaged by the contaminated water in Flint, Michigan. Jussie's commitment to serve the community began as a child. As he found professional success, he continued to donate time and money to charitable causes. Another factor that we urge your honor to consider is that the crime did not involve violence to others.
Tupelo, you're funny.
Charge indicate that Jussie ever posed a threat to public safety. Further, Jussie has already suffered. He has been vilified in the court of public.
Yes, exactly.
Professional reputation has been severely damaged. He has suffered lost career opportunities, the loss of income, and there are a number of people who rely on Jussie for financial assistance. Finally, I am deeply concerned about the physical safety and well-being of a well-known, non-violent Black gay man with a Jewish heritage who may be incarcerated within the U.S. prison system. For all the foregoing reasons, I believe the only fair and just outcome is to sentence Jussie Smollett to a non-incarceration alternative. With respect, we respectfully urge you to do so. Rainbow Push Coalition welcomes the opportunity to serve as a place for Jussie to resume his desire to serve the community. During the first year of COVID, we served more than 4,000 meals each day. We have a program that is designed to meet some of the issues homeless individuals face each and every day in the city while trying to survive. We believe that those who are impacted
3 hours and 12 minutes.
deserve an opportunity to be restored to a meaningful life and lives throughout community engagement and public service. We have worked diligently to transform the lives of young people in our Push Excel programs. I believe that Jussie has much to give to America, and this case is a stumbling block that should not become a setback to his future. We do not want Jussie to become another prison statistic, as he has way too much to offer. I stand ready, along with the board of directors and the several thousand members of the Rainbow Push Coalition, to support Jussie Smollett in his journey to wholeness. We want to assist this court in meting out justice for Jussie Smollett. Signed, the Reverend Jesse L. Jackson, C.
Thank you.
case clerk on behalf of the Illinois Innocence Project. To the Honorable Judge Lynn, I submit this letter in my personal capacity as co-director of the Illinois Innocence Project. This letter is provided in support of a non-custodial sentence for Jussie Smollett, and also to inform the court that if there is a community service component to Mr. Smollett's sentence, he would be welcome to do so under my direct supervision at the Illinois Innocence Project. At the outset, I want to be clear that the jury found Mr. Smollett guilty, and I respect the jury's verdict. I write to you today regarding the sentence and urge the court
You couldn't respect the verdict.
to fair sentence to Mr. Smollett. In high-profile cases,
Sad.
there is often a tone surrounding a case that seems to call for the harshest possible punishment because of the attention the case has garnered. I would urge your honor to silence out those loud voices and see Mr. Smollett for who he is, as a person before you, a human being. The old adage applies here: justice is the law tempered by mercy. Here, while the law may permit you to sentence Mr. Smollett to prison, incarcerating him would not be just. The relentless media coverage of this case is a unique punishment in and of itself for Mr. Smollett. He will carry the stain of this case for the rest of his life and spend the rest of his life and career working to rebuild and establish his credibility, his reputation, and good name. That lifetime sentence is something this court should consider as a unique punishment already dealt to Mr. Smollett in the court of public opinion. In fact, cases with media attention provide an opportunity for the court to show the public that justice, fairness, and mercy applies to everyone, no matter who they are. If the system doesn't treat a high-profile defendant justly, then what can be expected for the rest of us? If Mr. Smollett, who has no prior felony convictions and no violent background, is sent to prison on a Class 4 conviction, then what does that mean for an unknown defendant who has no one watching or advocating for him? This, of course, intersects with the disparate manner in which people of color are sentenced, with Black men receiving the most disproportionately high sentences.
Oh, now the black card.
Leaders around our state have put a focus on lessening the incarceration rates in Illinois prisons for justice-related reasons as well as due to COVID-19. There is no justifiable purpose to send Mr. Smollett to prison on a Class 4 conviction. This is especially true when Mr. Smollett could receive a non-custodial sentence, which includes community service where he could do good. Mr. Smollett has a long history of philanthropy which predates this case. As the well-known attorney and founder of the Equal Justice Initiative, Brian Stevenson, has said, each of us is more than the worst thing we've ever done. Mr. Smollett is no exception.
True, very true. We all have done wrong. But he's too old for this. He's too old for this.
At the Illinois Innocence Project, in the course of fulfilling our
trust
mission of
issue.
advocacy, education, and reform, we regularly work with volunteers in a variety of areas. Since 2001, the Illinois Innocence Project has had a robust volunteer program, working successfully with volunteers of various backgrounds who have engaged in work ranging from file organization to case evaluations to office support and more. We have found that volunteers working with us gain a close-up view of the brutal injustices faced by our clients who are all serving decades-long or life sentences for crimes of which they are actually innocent. This up-close view of the trauma inflicted upon these individuals and their loved ones is an awakening and often life-changing experience for our volunteers and staff. In my 9 years working at the Illinois Innocence Project and my 15 years as an attorney working in criminal defense, I have seen the cruelty and dehumanization of prison, as well as how prison impacts people in negative ways. Every person I've ever known who spent time in prison left with increased mental health needs and post-traumatic stress disorder. Incarceration should be reserved for crimes of violence and dangerous individuals, not for someone in Mr. Smollett's position who has no prior felony convictions, no violence in his past, is convicted of a probationable Class 4 offense, and who has much good to still offer this world. Prison time should not be given to satiate the public's calls for retribution. If this court sentences Mr. Smollett to probation with a component of community service, I will make myself available to the court and will comply with any orders of the court related to supervision, timekeeping, and project updates if Mr. Smollett were to have the opportunity to work with our organization. Thank you for your consideration. Sincerely, Lauren Caseberg.
This is so disturbing to be upholding this man. Major organizations, Jesse Jackson, Push, Samuel Jackson's wife, the Innocence Project in Chicago, you all have to shame yourselves. They brought this case back to the docket because they found evidence that he lied. This is ridiculous.
First is from Oscar-nominated winner of 4 Primetime Emmys and 2 Grammys and political activist Alfred Woodard.
Alfred Woodard. Oh, Alfred
Hoping
Woodard.
your loved ones are well and are finding a way forward in this time. I am writing
Hey, y'all.
to you today as someone who is more than a friend to Jussie Smollett. I am in my 60th decade, and when he was a young teen, as we worked, and we met when he was a young teen, as we worked together to bring shelter, health, and education to South Africa's AIDS orphans. Jussie referred to me as Mama Alfred. It is out of that bond that I make this appeal to you. Jussie was convicted of a Class 4 felony. I know it to be the least severe category of felonies in Illinois. I also have learned it is a well-established practice in your county, as well as around the country, to sentence Class 4 disorderly conduct cases to alternatives to incarceration, including second chance probation, or deferred prosecution. I respect that an important aspect a trial judge must consider when sentencing someone is the potential for recidivism. Jussie's lack of a felony criminal record, as well as his many years of humanitarian work on behalf of communities in need, is a strong signal that he carries no risk of recidivism. For years, I have been at his side as he's lit up rooms full of elders,
Hey, Krista.
men and women.
I don't know what he would do it not. I can't say he want to go back to jail or go to jail 2 years from now. He's a liar.
Reach for the kind of joy that Jussie brings. Now, some conscientious people reach out to those without access after they achieve success in their given fields. Jussie has been a compassionate presence and advocate for those without means since he was a boy. His dedicated work as an artist brought him success and allowed him to bring his natural impulse to be of assistance to an even wider field of effectiveness. Jussie has kept his heart, his wallet, and his schedule wide open to those suffering among us. Judge Lynn, I know you and I are meeting, quote unquote, in a situation that would cause some, quote unquote, mamas to lower their eyes. But I must tell you, I am proud of this man, who I have known to be an exceptionally kind human being. It is an honor to write you on his behalf, because I get to sit and think on Jussie this afternoon. It brings up wonderful
Oh,
thoughts.
my Lord.
My dear friend Jussie Smollett has been convicted.
This is about to be a 6-hour live. Fooling with this nut.
He never has been, and certainly is not now, a public safety risk. He has carried himself with dignity and self-control throughout this process of the last few years. He has delved deeper spiritually in self-realization to come through a vicious public excoriation that would have crushed or inflamed lesser men. The punishing has been relentless and has left nothing to be taken away. He has already paid a professional and personal price that few in real power have even for crimes against the health and safety of millions. Through it all, Jussie has stood like the good man I know him to be. Bottom line, if he is incarcerated, I fear for his safety. I fear for his safety.
Oh, give it a rest. Ain't nobody done nothing to him since then.
It is your fairness and your discernment.
This lady ought to be ashamed of herself. These people are stupid.
Is relying upon in this matter. You hold the keys to the freedom and the future of a great giver, Jussie Smollett.
No, he held his own future.
And hope to people whose every days depend on that healing. I beg your leniency. Sincerely, Alfred Woodard.
Alfred Woodard. Alfred Woodard, really?
Last letter is from Derek Johnson.
Yeah. She's involved in interracial dating. She has a white husband, mixed children. Is that where we're going with this?
I write today in my capacity as president and CEO of the NAACP. Formed in 1909, the NAACP is the oldest and largest civil rights organization in the United States.
Tupelo, you're so funny.
Black people are incarcerated at more than 5 times whites and frequently receive
So funny.
sentencing. In Illinois, Black defendants convicted of a felony were more likely than white defendants to be sentenced to prison at a 57% and 39% rate, respectively. A mainstay of our organization continues to be advocacy for fair treatment of persons of color by the criminal justice system. This brings us to the subject of the upcoming sentencing of Jussie Smollett. It would be an understatement to say that an inordinate amount of attention has been given to Mr. Smollett's case. This case involves no drugs, no theft, no sex, no property damage, and no physical injury to anyone other than the defendant. Despite the attention paid to it by the media, at its heart, this case involves a low-level, non-violent offense. We urge the court to keep this truth in mind when sentencing Mr. Smollett. By way of background, Mr. Smollett has an extensive history in civil rights advocacy and philanthropy. Mr. Smollett personally donated more than $500,000 to Black organizations and gave $125,000 in proceeds from his music tour to organizations including the organizations working for Black, LGBTQ+, and women's rights, including the Black AIDS Institute, which provides high-quality, direct HIV services to Black people, the Flint Kids Fund, which funds programs aimed to address and mitigate the impact of lead poisoning and the trauma suffered by children in Flint, Michigan, the Trayvon Martin Foundation, whose main purpose is to provide emotional and financial support to families who have lost a child to gun violence, the Know Your Rights Camp, whose mission is to advance the liberation and well-being of Black and brown communities through education, self-empowerment, mass mobilization, and the creation of new systems that elevate the next generation of change leaders. In 2018, Mr. Smollett surprised a 6-year-old double amputee with a wheelchair accessible van after learning that the child's school district did not own such a vehicle. Mr. Smollett has been a recognized supporter of the Human Rights Campaign, a civil rights organization that strives to end discrimination against LGBTQ+ people and realize a world that achieves fundamental fairness and equality for all. Lest there be an argument that such donations and activities were made as a part of any PR damage control, such acts all preceded the 2019 events that resulted in charges being brought against Mr. Smollett. In 2018, after learning that Bennett College, an all-women's HBCU, which stands for Historically Black College and University, was on the brink of losing its accreditation, Mr. Smollett and his brother helped the institute raise the funds needed to retain accreditation. In fact, the college needed only $5 million. Mr. Smollett and his brother led a campaign that was so successful it raised $8 million. Mr. Smollett's civil rights work began when he was a child who served as an NAACP youth volunteer. In 2016, Mr. Smollett won the Chairman's Award at the NAACP Image Awards. The Chairman's Award is given in recognition of individuals who have committed themselves to acts of public service while using their platforms to create effective change. In short, Mr. Smollett has demonstrated a long-standing commitment to helping others. We believe that incarcerating Mr. Smollett would be solely punitive and would serve no purpose. As this court may know, in 2015, Illinois Governor Bruce Rauner created a criminal justice task force to identify areas of the criminal justice system that could be reformed that will result in a 25% reduction in the prison population by 2025. One such proposal for reform was reducing the incarceration rate of persons convicted of Class 4 nonviolent felonies. This is precisely the type of offense of which Mr. Smollett was convicted. Finally, Mr. Smollett does not pose, nor has he ever posed, a threat to anyone. Thus, we respectfully ask, assuming this court is inclined to sentence Mr. Smollett to anything other than a monetary fine or a suspended sentence, that the court sentence Mr. Smollett to probation and mandatory community service. Respectfully submitted, Derek Johnson, President and CEO of NAACP. Thank you. Thank you, Judge, for your time.
Okay, we wish to publish no further letters, Your Honor. We incorporate the other letters into the record.
Incorporated for further letters. I'm ready to keep going. The lawyers need a break. Are you ready to go?
Maybe
We have a short break. Yeah, sure you can. Yes. Very short. 5 minutes. 5-minute recess.
5-minute recess. Sorry it's taking so long. I'm 3 hours and 29 minutes into this live. I've actually done 1,000 things since this live started. Got dressed, did my hair, made coffee. Damn. This is crazy to me. Hour for hour for hour, all these people speaking, upholding him. Let me say this before they jump back. I cannot believe these people are upholding this man. I've said this 1,000 times. You do not know people. We are all flawed. We all made mistakes. We will continue to make mistakes, do wrong, woo, woo, woo. But this is ridiculous to me that you've seen the evidence of these people. And yet they are sitting here acting as if it's no big deal what he's done. This is sad to me. This is utterly sad to me. It's just really, really sick that this is going on for hours. It is 5:40. I've been on here since 2:30. 3 hours of nothing. 3.5 hours I've been on. Live. Playing audio from these fools. And it's not to be nasty, but it's the truth. I believe there's a conflict of interest with the first DA, the black lady. So then they kept investigating. And once they got more information, they realized, okay, we don't believe this person, Jussie Smollett. We do believe he orchestrated this crime with these brothers. They've admitted that they aided him. He paid them. Who would lie about that? Think about it. Honestly, think about it. Why would two people say, yes, he orchestrated this crime, he paid us? Why not just lie? Even if they saw you buying the hats, the gear, whatever, you could say, well, I bought some stuff for myself. What's your point? No, I didn't do this. No, I didn't hit him, push him, shove him, whatever the accusations are. They could have easily lied. That's what people don't seem to understand. These goofy ass people that's upholding him. Those brothers didn't have to admit to nothing. They could have easily said, I don't know what you're talking about. I plead the fifth. That's all they had to do. But they probably were scared because I don't know what their, citizenship is here in the United States. They could have been here on a visa, whatever. I haven't dug into it to find out. But nonetheless, they told, yeah, he paid us. We didn't hurt him. We didn't harm him. This was all his doing for whatever reason. So I don't understand why these people don't see these guys are telling the truth. And then the fact of bringing that bullshit about kissing in the bathhouse and hanging together, smoking weed, woo, woo, woo. That was a low blow. Because let's just say that guy is gay, one of the brothers. Maybe he doesn't want the world to know he's homosexual, bisexual, or whatever. In court, he denied months ago that he is a homosexual. What was he supposed to say? Oh, yeah, by the way, I'm gay. I'm gay. I like him. We fooled around sometimes, and I pretended to hurt him for a couple of $1,000. The fuck? This is crazy to me. This is utterly, utterly crazy to me. This is nonsense. This is utter nonsense. That gay card was below the belt. It is one thing to say they're lying on me, I didn't pay them, but then to implicate one of them as a homosexual because you're gay was low down. And even if there's some truth to them messing around or whatever, that boy ain't gonna never admit to being gay. And I wouldn't either. I wouldn't either. Because you don't have no business putting me on blast because your ass got caught with your foot in the trap exacting a hoax. Because you're mad at the studio for not paying you what you think you're worth. Well, if you think you're worth more than what they were paying you, then you should have told them, hey, at the end of this contract, woo, 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 I'm out. I'm not re-signing. And then you should have took your ass on. People do it every day in Hollywood. They don't like the money they're getting paid. They don't come back the next season. Okay? They either finish their contract or they break their contract. And that's all this bobblehead had to do. Bow out gracefully. He's been a pathological liar. That woman testifying about who he was at 16, he was probably lying at 16. He probably embellished a lot of stories at 16, 15, 13. See you later. He's probably been lying, making up stuff. Like one of my classmates used to lie and make up stuff in high school. Oh, I went to Paris for spring break. He ain't went no damn where. Do you follow me? Jussie Smollett is that person. He's been lying. Because let me tell you something. You don't wake up in your mid-30s and start making up stories. Especially this elaborate and paying somebody to hurt you, putting a noose around your neck. You've been lying your entire life. Hold on, let's see what they got now. Thank you. Exactly. He's not going to stop lying. That's one thing he's not going to do. And I wouldn't trust dealing with him. I wouldn't date him. I wouldn't do nothing with him. Because somebody that's this diabolical, you could never trust. This is a trait you're not just going to get therapy for. Oh, let me go see a psychiatrist to stop lying.
We'll hear from the Office of Special Prosecutor, arguments and aggravation.
Thank you, Your Honor. As Your Honor knows, this is the sentencing phase of the case where we, from the Special Prosecutor's Office, get a chance to kind of sit back and reflect with the court for a bit and talk about whether there are aggravating special circumstances in this case that we want to call to Your Honor's attention. So you can consider or focus on them if you choose to in rigorous sense in this case. There are three. There's three I want to talk about. Number one, I do want to talk about the underlying serious criminal misconduct that Mr. Smollett engaged in and that he was convicted of by a jury after they heard all the evidence, and they, the jury, made the decision that he was guilty of 5 felony offenses. I want to talk about that. We've heard a lot about that in this sentencing hearing, a lot of talk about how it's kind of a low-level thing, not a big deal. I want to talk about it. Number two, another aggravating circumstance that I think is a big issue is that during this trial, Mr. Smollett made the choice, sitting here in front of a jury, listening to evidence, he decided to beat the case and go in front of a jury and take an oath to tell the truth and decide to lie to them, and lie to them for several hours. It was an effort to obstruct justice in this courtroom, to try to convince a jury to ignore evidence and accept his lies, and they didn't do it. They rejected it all. And after, 2 or 3 hours of deliberation, found him guilty of 5 counts. So I want to talk about that. The third is the issue of contrition. As far as I know, as I stand before Your Honor, in the 3 years that this case has been pending, 3 years, Mr. Smollett has never made any statement, publicly or in a courtroom or in a court pleading, to ever accept any acknowledgement that he's responsible for what happened here, to admit that he in fact engaged in wrongdoing, to apologize for making mistakes. None of that has happened. Not a single act of contrition has happened so far in this case, and I at least want to talk about that as a third factor. Let me go through them one at a time. On the first one, on the seriousness of misconduct, I know we've heard a lot about this, and it's a low-level offense, but I want to talk about it in a minute, because what I believe, if you look at the evidence that was introduced during the trial, what you see is that Mr. Smollett actually engaged in a very well-thought-out plan, a calculated plan for him to fake a hate crime to benefit himself because he's black and gay. He made the choice. He didn't want to fake an automobile accident. He made a choice. He wanted to fake a hate crime to benefit himself because he's black and gay. And he then made a choice. He made the choice to falsely report it to the Chicago Police Department because he wanted public attention to it. The only reason the brothers had nothing to do with that decision, that was Mr. Smollett's decision. He actually wanted public attention, called to the fact that he was reporting a hate crime. He wanted it to be made public, and that's why he reported it to the Chicago Police Department. He's the one that made that choice. Remember, he actually, when he planned out the fake attack, he wanted it to be put on a camera. There was a police camera overhead near his apartment building. He wanted that filmed. In fact, that's why he told the brothers where to do the attack, because he's the one that wanted a great deal of public attention, called to this because he thought he would benefit from it. And then he made the decision. It wasn't like he sat down with a policeman for 10 minutes. You've heard 5 different police officers testify in detail. He spent hours talking to police officers, going through details that were all false, to convince them that there really was a real hate crime, and he lied to them over and over and over again. And the idea that lying to law enforcement, taking their attention away from other crimes and criminal activity in order to benefit himself is some type of low-level, insignificant activity. I respectfully reject that as not being consistent with the evidence. And respectfully, to what I heard from others here today, there were consequences to others of what he did. And that's something the court is allowed to take into consideration. What Mr. Smollett did in this case is he denigrated, degraded true hate crimes, and he marginalized the people who are true victims of hate crimes. That is what he did. And he did that knowingly. He knew exactly what was going to happen. He didn't know he was going to get caught, but by what he did here, he's the one that made a choice that resulted in true hate crimes being denigrated, degraded, and true victims being marginalized. We know, in fact, it's in the Chicago Police Department report, that the hate crime victims of hate crimes are frequently minorities, whether it's based on race, religion, or sexual orientation. And studies show that that group of people are reluctant to report criminal activity to police, hate crimes to the police. And that was discussed in the Chicago Police Department report. There are studies that support that. It takes a tremendous amount of courage on behalf of someone who's been truly victimized of a hate crime to have the courage to come forward, to go through the process of reporting it, to go through our criminal justice system as a witness. It takes courage. And what Mr. Smollett did in this case clearly would have a marginalized, discouraging influence. It hurt the effort to have people come forward and report hate crimes. And that was wrong. That is serious misconduct and a serious consequence of what he did. And he did it in 2019. And if I want to go back to that time period, that's a time period where there was a lot of racial tension, divisiveness. Hate crimes were becoming far too common, and police were accused of not paying enough attention to it. And that society was trying to find a way, at least this is my view, trying to find a way to make it clear that it needs to be reported. Hate crime needs to be addressed by law enforcement machinery in this country. And what he did, what Mr. Smollett did, to marginalize that, to discourage people from coming forward, I respectfully suggest is wrong. And that, and it was a normal consequence of what he did in order to benefit himself. Remember what the facts are. He made the choice in January of 2019 he felt that Empire was not paying enough attention to a hate letter about him. It came to him, and he wasn't getting enough attention. And he decided to fake a hate crime to benefit himself. He wanted to benefit himself. That's why he did it. And he hatched the plan, and Your Honor, he did it all. Nobody else did any of this. I know you know the facts, but he did it all. He planned everything out at that time. He recruited the brothers. He went forward with this plan, and even to the point of trying to work out where they would actually do a dry run, so that the brothers would know exactly where to do the attack at. All of that, he told them what to buy, what derogatory, homophobic, racial slurs to utter, to try to pretend as if there's whites involved by yelling out mega country. He owned every bit of the plan, and he worked hard on it. He planned it out, and he executed on it, and he owns that for doing that. And so, yes, it is serious misconduct on his part, and it had broad ramifications. And the true victims are, of course, number one, the true hate crime victims that are not going to report these crimes. They are the true victims. The police department, though, is a victim, and I'm going to talk about that, because sometimes the Chicago Police Department gets criticized for not doing things the way maybe people think it should be done. I'm not here to defend the Chicago Police Department, but I'm telling you, in this case, this Chicago Police Department shined. When this, and then we hear in this courtroom, the police department paid too much attention to it. They shouldn't have invested. They shouldn't have spent so many hours investigating this misconduct. And they argued last night in the filing with Your Honor. They argued, well, we shouldn't have to pay restitution for all that because the police department spent too much time on it.
I guess I need a part two to this.
I wonder what would have happened if the Chicago Police Department took
This is crazy.
this hate crime, which on its face, by the way, is a heinous, serious, awful hate crime. Awful. Ropes, lynchings, gasoline. It clearly called out for a thorough investigation, and we put 5 police officers on the stand. They testified in great detail to four different occasions.
Oh my God, how long is this going to go on?
They described
Approaching 5 p.m. in Chicago right now, 6 p.m. here.
police hours.
I had no idea it would run this long. I'd have never gone live on this subject matter. Because I could have been done with my live by now, with my other content.
I believe that the effort of the Chicago Police Department here, and when you look at the evidence, the fact that this police department, within, I think, 15 days, figured out what happened here. I mean, if you remember, what they were able to do in this case, I think was truly amazing, because what they did is that they were able to locate some surveillance tapes of these 2 suspects being dropped off around 1:15 in the morning in the Streeterville area. They traced it all through that area of where the suspects went. They traced that cab back to where the Asadero brothers got into it in the, I think around Wells North. And
I'm going to have to do a part 2 because this is too winded.
Figured out what happened here. And that the point of that is that, and by the way, they did it, Your Honor. They did that as an incredible effort on their part, when we now know from the evidence at trial, that Smollett, while he was reporting a hate crime, he actually was trying to obstruct the police. He didn't want the police to actually find out who the culprits were, because he was afraid they would turn on him and testify. So he refused to produce his phone. You heard all the evidence. He refused to produce it because there was 50 contacts on there with Abel Asadero that he didn't want them to find. So he just refused to cooperate. Number 2, he refused to let the police look at his Northwestern medical records the day that he reported the crime, because he knew that he wasn't seriously injured, and that would not support his argument about the attack. So he refused to cooperate. And then he wouldn't even do a 3-second DNA swab when he had reported this, and reported that the rope may have the DNA on it of these culprits, but the police wanted to eliminate his DNA, and he wouldn't do it. So while he's reporting this, as far as you considering whether it's a serious crime or not, I respectfully suggest that the fact that he not only planned out to falsely report it, but then to obstruct the police investigation. And yes, the issue about whether it's serious, and I've heard a lot about, well, no one goes to jail. That's not true. Every case, Your Honor, if anyone knows better than you, each case is decided individually. But I did go out and do some research because I was curious about all this stuff I'm hearing that, well, no one goes to jail for this. That's just not true, by the way. I think there's 6 cases in the last 5 years that we found in the research of people in Illinois going to jail for this very conduct of falsely reporting crimes to police. It is a serious course of criminal misconduct to do it. It's a felony. And I think there was one decided by appellate court 4 months ago, which involved reporting to the police that the person was hit by a police car when they weren't.
Okay.
I think what happened here was a lot worse than that, and that person got 14 months incarceration for filing a false police report. So
I hate to log off and then they go ahead and read the sentencing. That's what I hate, because I do need to come back and bring the other content, because this is too long.
Aggravating factor number 2 is lying under oath. I'm not going to go through it. Your Honor heard the testimony.
Let me see what he says. If not, I will conclude this live and come back a little later
Choices to be made, and defendants can make choices.
and finish the other stories about
Mr. Smollett made the choice that he could deceive that jury.
Cynthia Cole and Megan Boswell.
About so many different things. I'm not even going to. I was going to summarize some of them, but I don't even want it. I don't need to. You heard what happened during the course of the trial. Testimony that he went out and at 2 o'clock in the morning to buy eggs from Walgreens when the Walgreens was not even a 24-hour Walgreens. It was a ridiculous story. The fact that one of the attackers is white and he didn't even know who attacked him was ridiculous.
Yes,
the
ridiculous.
Fact that the
Yes.
brothers had no foreknowledge and just happened to stumble over there into a Streeterville that they didn't live in and were happened to be there at 2 o'clock in the morning.
Right.
When he was out going through that in that stairwell. All of that were intentional lies. And by the way, people do not, that going in front of a jury and deciding to lie under oath to see if you can beat the case and obstruct justice is a serious course of criminal misconduct that I think should be taken into consideration. I also will tell Your Honor that the issue of lack of contrition here, I do think is an important issue. And Your Honor can decide how much to give to that. But the reason I went and did some research on this, Your Honor, because I wanted to make sure I was handling this issue properly before Your Honor. And so I went and did some research. And the Illinois Supreme Court has made a big deal.
This has gotten winded. I'm going to conclude here. I'll be back later when they read it, because I had no idea the court was going to run this long to read a verdict. A sentencing. I'm so sorry. And I had 2 other stories intertwined with this one. So this has been like a waste of a live, because there were other important stories to bring to you. I will be back shortly to continue the information. But I thank you all for tuning in. If you want to donate to the channel, $Big Angie 129 Cash App. All super chat to welcome during the live. I will be back with the rest of my commentary a little later, because I've got to take care of some other things before this evening ends. But thank you all for following the content. At the moment, they're still giving their testimonies of why he should get a sentence and not get a sentence. Thank you all so much for tuning in, mods that join me. I'll be back a little bit later to finish this live part 2 of the sentencing. Thank you all so much for joining me. God bless all of you. This is Everyday Shenanigans. Thank you so much for your time.